April
Recording in progress.
2023. I'm Jose Smith, the special magistrate assigned to your cases today in the city. The special magistrate is empowered under the Florida statutes and the code of the city of North Miami to hold code enforcement code violation hearings. The purpose of this hearing is to determine if a code violation exists at your property as observed and cited by a code enforcement officer of the city. If the city is not able to prove this case, then I will dismiss it and you may leave. These proceedings are being recorded, so all persons who are speaking should do so one at a time to ensure that all testimony is clearly audible on the recording. If English is not your primary language, then please inform me when I call your case. We have interpreters and translators who will assist you during these proceedings. When your case is called, the property owner, agent for the property owner, and any witness that you may have should announce yourselves. And when asked, please speak directly into the microphone and say out loud your name, your business, your mailing address, and your relationship to the property. If you are not the property owner or an attorney at law representing the property owner, then you must present a power of attorney or an affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you're aware of and understand the violation that is being heard today, and if you understand what is required to resolve that violation. Please answer accordingly. The city will present the case first, then the property owner will be given an opportunity to testify on its own behalf, bring witnesses, testify, to present evidence and photographs, and to cross-examine or question the city's witnesses. Following the case presentation, I will issue findings of fact on the case. If I find that a violation of city codes exists or existed at your property, then depending upon the type of case, I will set an abatement date for the violation to be resolved. Or for repeat violations, I will impose a daily fine amount. For new non-repeat cases, my order will include an abatement date by which you must resolve the violation and a daily fine amount that I may impose at a future hearing should the violation not be resolved by the abatement date. If I find sufficient cause to postpone enforcement action at this time, I will table the case and move it to another hearing date in the future. If you do not agree with my findings of fact or my ruling, then the property owner may appeal the administrative order on the case to the Circuit Court of Dade County. An appeal must be filed within 30 days of the date of the execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision made by the special magistrate with respect to any matter considered at these proceedings, then the person will need a record, a verbatim record or transcript of the proceedings. This record includes the testimony and evidence upon which the appeal is to be based. The cost of obtaining the verbatim record shall be the sole responsibility of the appellant property owner. And it is recommended that persons who plan to appeal their case should provide their own court reporter at these proceedings. Pursuant to city code, if the city of North Miami prevails in prosecuting a case before the special magistrate, the city shall be entitled to recover all costs incurred in prosecuting the case. The current cost assessment amount is $100 per case. Once the city records an order that imposes a fine and authorizes a lien against the property, then the city will charge additional administrative fees to record and release the lien. So at this point, I'll turn it over to staff to do the appropriate proceedings. Ms. Patterson?
Thank you. Clerk, go ahead just a second. Again, I have several people signed in as April 4th hearing. please rename yourself so that we can identify who you are and be able to allow access to you at the appropriate time. I have about 5 people that are signed in as April 4th hearing. Please rename yourself. Clerk, go ahead.
Good morning. Can you guys hear me?
Yes.
Good morning, and thank you for participating in today's special magistrate hearing. I'll review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on the case. If you are using 2 devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive notification giving you access to the audio and video so that you may give your testimony. If you are physically here in person and wish to give testimony, you must sign in with the court clerk and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the code compliance office to be provided access to a computer. If you would like to speak on behalf of a case, once the case is called, you should click the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when your case is called. The magistrate that include all the instructions for today's hearing.
At this time, we'll go ahead and do the pledge so that everybody can enable their cameras to do the pledge. Oh, is the officer here, Peggy?
She just pulled up. She walking in now.
Okay. Okay. Again, staff, April 4th hearings, please rename yourselves. Look at the screen, and if yours says April 4th hearing, please rename yourself. Just a moment, Magistrate. We're just waiting on our officer to come in to administer the pledge.
That's fine.
I'm here.
Okay, I don't see you.
Welcome,
is the
officer.
camera on? Okay. All right, there we go.
Are we ready?
Yes.
Yes.
Okay. I pledge allegiance
Yes.
to the flag of the United States of America and to the republic
for
which it stands, one nation, under God, indivisible, with liberty
and justice
for all.
Thank you. At this time, if all staff that's going to be giving testimony today, if you can leave your cameras and videos enabled to receive the oath. We're ready.
Okay. Do you swear or affirm that the testimony you are about to give in these proceedings will be the truth, the whole truth, and nothing but the truth? If so, say aloud, I do.
I do.
Thank you.
Thank you. Can we get the translators, please? Staff, you can disable interpreters if you can enable.
Okay.
Go ahead.
Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say, I do.
I do.
Thank you.
Magistrate, we're ready. I do believe that
Okay,
there are
any additions, deletions, amendments, corrections to the agenda?
Yes, there is, Magistrate. It's with item number 43 through 46, which is Trinity Church, Inc., case number CEGEF 2022-0025, case number CEGMP 2022-00100, case number CEJNK 2022-00026, and case number CEPPK 2022-00018. All of those cases have been postponed, Magistrate.
Okay, let me clarify that. All cases involving Trinity Church, beginning with case number 43 through 46, all of those cases are being postponed?
That's correct.
All of them? Okay.
Yeah, they recently retained counsel, and in order to give counsel an opportunity to review the files, we gave them an additional 30 days.
Okay. Anything else?
No, that's all the amendments to today's agenda.
Okay, are we ready to start?
Yes, I'll continue with the first cases, which is item number 1 through 4. 12200 North Miami Holdings, LLC. The officer is Shannon Sanders, and the case number for each one of them, item number 1 is CEEXC 2022000026. Item number 2, CEFAW 20220065. Item number 3, case number CEMHE 20220038. And item number 4, case number is CESCN 20220020.
We have a Roger Lopez here on behalf of these cases. Mr. Lopez, if you can enable your audio and video.
Good morning, Your Honor.
Good morning, sir.
Roger, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
Okay, we're going to hear them one at a time, beginning with number 1 and then 2, 3, and 4. Sir, tell us your full name, address, and your association to the property.
Roger Lopez, 13322 Southwest 128th Street, Miami, Florida, 33186. I represent the owner. It's owned by an LLC. I have a corporate resolution to say that I have the authority to enter into any and all matters with the city for permits and the likes.
Okay, looking at Sunbiz, which is part of the record here, the 2 managers listed, Felix Figueroa Goncalves and Leticia Cicera, are they basically the owners of the properties?
It's an LLC, so they're members. So
they're members.
Correct.
Okay. All right. And they gave you authority to act on their behalf on these matters.
That is correct.
Okay. So with that said, let's start with number 1. Let me hear from the city first.
Shannon Sanders, City of North Miami Co-Compliance Officer. The first case that we're hearing is CEEXC 2022-00026. This case is in reference to the exterior walls of the building that are in need of repair. Throughout the entire building, when I did my inspection, they are cracks throughout the entire building. I have only had one contact or one conversation with any individual from the property. She identified herself as the property manager. I apologize, I don't remember her name. But as you see in the pictures depicted, there's cracks throughout the stairways. There's cracks throughout the railings, in the walls, along some of the balcony areas. They were fully understanding that a permit needed to be obtained to repair those cracks. As of my last reinspection, cracks still remained and no permit had been obtained.
Okay. This is a 2-story multifamily building?
Yes, it is.
Any life safety issues?
Well, those cracks seem to be, pretty large, and they're along the stairway areas. So I would consider that a life safety issue,
Have you had any conversations with the property owner regarding repairs for getting a permit, getting the corrections done?
I didn't speak with the property owner, but it was a young lady who I met at the property when I did actually the reinspection. She identified herself as the new property manager. And at that time, we did speak about her obtaining all the necessary permits for things that needed to be done at the property. Okay,
Mr. Lopez, you've seen the report, you've seen the photographs, you've been at the property, I'm sure. What say you?
That's correct, Your Honor. So on that property, we pulled several permits, one of which was for the roof. That job was completed. Still missing. We did the fascia, we did the soffit and whatnot. It remains to be painted. We also have a permit that is open right now to close all the doors, to replace all the front doors and remove all the kitchen doors and block them up. Work is being done as we speak. That's a picture of what's happening. Once this permit is complete, then we will put a permit for weatherproofing the building and painting it as well. And that will include getting any cracks, which we have our contractor looked at it, and there's no life safety issues with it. They're just cracks that need to be repaired. And once the repair or the stock is repaired, then we're going to paint.
Is the building occupied? Is the building occupied?
The building is fully occupied, sir. Yes.
Okay. How much time do you need to make those repairs to the cracks?
If we started the work on which I call for partial inspection for these, the blocking up of the doors. Once that permit gets through, and when the process of changing 24 doors, all front doors, and closing all the kitchens, then I'm planning on pulling the permit possibly next week, depending on what, how long it takes for the building department to issue those permits. I think a fair time will be 90 days. Because it's taking the city about 30 days or so to approve a permit. So,
okay. City is. I know that we've had some issues regarding abatement dates. When I say 30 days, is it 30 days or is it the next the date when you schedule the abatement date? What? Explain to me how that process works.
If possible, Magistrate, I believe, and the clerk can confirm, but we do have a designated set of dates. They don't necessarily align with 30, 60, and 90 for operational reasons. So we would respectfully ask that you would adhere to the date that is provided on the document. So you would have to use that exact date.
Okay, I don't presently have that document in front of me. Give me the first 3 abatement dates on the list. When is the first one which would align to a 30-day extension, the next one, and then the one after that?
The one to a 30-day extension would be for, give me 1 second.
Can you speak up a little bit? I can't hear you.
Can you hear me?
Yeah.
All right. The one for a 30-day extension would be May 18th.
So May 18th would be 30 days.
So it's not 30, but it's just the next. So just give the next 3, Peggy. What would be the next 3 abatement dates?
The next 3 abatement date, May 18th, June 15th, and July 20th.
What's the one in the middle? June
15th.
Okay. So if I inadvertently say 30 days, I mean May 18th. If I inadvertently say 60 days, it'll be June 15th. And if I say 90 days, is July 20th. In this particular case, because of a potential, I know that you can test this, Mr. Lopez, but I have to defer to the code officer on the question of life safety because of the cracks and where the cracks are located, and the number of them. Maybe 90% of them are not, but maybe 10% are life safety. And I'm sure that, and we're fortunate to have the building official here as part of this meeting. I'm sure that his office will work with you expeditiously. So instead of the 90 days that you requested, I'm going to give you 60 days or through June 15th, within which to get your permit and weatherproof and seal the cracks and do whatever else is called for in this particular violation. If there is some delay or if there is a bureaucratic problem, I'm sure that the building official who is here present will work with you, but we need to get these cracks addressed. And so the abatement date is June 15th.
Thank you.
Next case, magistrate, same address, 12200 Northeast 6th Avenue, is for fencing walls for case number CE FAW 2022-00065. I first initially inspected this property on June 17, 2022, whereas I observed dirt stained cracks throughout the cement wall. There's a cement wall that's surrounding the property, or on the west side of the property, I would consider, that is, as you see in the pictures, clearly dirt stained, cracked, needs some little TLC. As of my last reinspection, the violation still remains. I again had a conversation with the property manager, explained that that needs to be cleaned. I don't think a permit is being needed because, it doesn't seem to be, many large, gadgets or anything. But again, violation still remains, and it needs to be cleaned and repainted.
Okay, now just to distinguish this case from the other cases, we're talking here about a cement wall that is dirty and has mildew, and that shouldn't take more than 30 days, 40 days to fix. Would you agree with me, Mr. Lopez, or is there a problem there?
Absolutely, Your Honor. There was a misunderstanding. They said the wall. We understood it was the back of the building. So that was sort of like painted, pressure cleaned and painted. From the picture, what I see is that's a wall. It's a fence for all intent and purposes, a CBS fence that separates the property from the other one on the east side of the property, or the west side of the property.
I don't see that as a problem. So we're going to table that, and we'll hear that on we'll table it until May 18th.
Thank you, Your Honor. Okay,
the third case is for the extermination report. That case is CE MHE 2022-00038. That case, magistrate, I have it marked as dismissed. They have abated that violation. I apologize, but I just saw the email this morning, whereas they sent the email, they did send it to me on the reinspection date. But, I'm just getting back to work this morning after being out for a little while. So that case, I did comply.
Okay, so you've got the extermination report, so that case is hereby dismissed.
That's correct.
Next case is the screens are missing.
Final case for windows and screens, case number CE SCN 2022-00020. Again, that violation was initially observed on June 15, 2022, where I was doing my minimum housing inspection. Again, at that time, I noticed, several windows that had missing screens on the windows. Notices were sent out to the property. I did not have any conversation until the notice to appear was posted at the property. At that time, again, the property manager contacted me. We walked throughout the property. She is fully aware, what windows and what doors need to have screens on them. As of my last reinspection, the screens were still missing. So I'll let, the individual, Mr. Lopez, explain what's going on with that violation and why those screens remain missing.
Yeah, before he explains, I didn't see any photos in the file. Do you have any photos of the missing screens? What are we talking about? Windows, doors, sliding glass doors? What?
It's windows. They're windows.
Okay, windows and doors. Okay, Mr. Lopez, any problem with that?
No problem at all. So initially, back in June, there were multiple screens. As you can imagine, the screens are on the outside of the windows. Some were taken out, broken by whomever. I'm not going to accuse anybody. So we replaced a bunch of them, including screens, sliding door screens and whatnot. There was one that was missed upon the reinspection by Officer Sanders. That was noted. I think I want to say apartment 206. That was emailed to her on 3/20. Furthermore, last night I emailed it again to Ms. Patterson. where we show the picture of the screen actually replaced.
Only one screen needed?
There's only one screen missing, yes. We had like
Right.
10 or 12 back in the day. Back in June, we replaced about 11. We replaced them all, but apparently, this
All
other
right.
one.
We're not going to dismiss the case until the city has had a chance to go out
Perfect.
there and do a final inspection. But nonetheless, we will, assuming that the violation has been corrected, it won't come back to me. But if there's still a problem with the screens, then I'll hear it on May 18th, along with the other issues.
No problem. That's an ongoing problem. That's the reason why we're also closing the kitchen doors, because all those jealousy windows are broken, they're stolen, and it's also an issue with the screens. But unfortunately, I can't replace the windows.
I appreciate your candor. I appreciate the fact that you're willing to move this forward. I know you've done some work up to now. And as we always say, our role here is to comply. It's not to punish people, but to comply. So as long as you're moving along and comply with my abatement dates, we'll be fine. All right?
Thank you.
Anything else?
Magistrate, just to confirm, all those cases were tabled, correct?
I'm sorry?
All of his cases was tabled? Because there's no...
Yes, all of these cases are tabled. One was for June, which takes a little bit longer. He asked for 90 days. I gave him 60, and I encouraged him to talk to the building official if there's a problem. The others will be abated by May 10th with no adjudication, just tabling the case for the moment.
Now, just to confirm, the first one, Mr. Lopez, June 15th is your abatement date. And for the other cases is May 18th is your abatement date, which is the date you're supposed to be in compliance.
That is my ruling.
Your Honor, I thought you dismissed item number 3. It was compliance.
Yeah, number
So what-
3, we all agree there has been compliance. The extermination report has been submitted, and you've told me, Ms. Sanders, that you have received it. And so on that case, we're going to dismiss it.
Yes, I have it marked down as well for compliance by dismiss.
Okay?
Noted. I'm going to go ahead and proceed with item number 6 and 7, which is 775 Northeast 138th Street, LLC. Care of Brian Price Stirrup, sorry if I'm butchering your name, and Associates. Case number is CEBPR 2022000578. And item number 7, case number is CERCV 2022000249. And the officer is Genaro Murillo.
I have a Carlos Alvarado here on behalf of this property. If you would enable your camera and audio, please. Carlos, if you can enable your audio and video, please.
Carlos Alvarado.
You might need the Spanish interpreter.
Okay, so should I call him?
Yes, please.
Hola, buenos días, señor Carlos Alvarado. Por favor, si se puede.
I don't see him. There you go.
Here you go.
You see me? Yes.
Can you please raise your right hand?
Señor, por favor, ¿puede levantar su mano derecha?
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God. Please say I do.
Jura solemnemente que o afirma que su testimonio, el que estará proveyendo el día de hoy, será la verdad y nada más que la verdad en el nombre de Dios.
Sí.
Yes.
Okay, so you understand the nature of the case? You understand why you're here?
Entonces, ¿usted entiende la naturaleza del caso? ¿Entiende por qué usted está aquí?
Sí.
Yes.
Okay. What is your relationship to the property, sir?
¿Cuál es su relación con la propiedad, señor?
Bueno, yo les represento a ellos parte de las casas que tienen acá, ¿no? En la ciudad de Miami, porque ellos viven en Inglaterra, ¿no? Y yo vivo en una de ellas también.
So I represent part of the houses here in Miami, since the owners, they live in the UK, and I live in there as well.
Who's the owner?
¿Quién es el dueño?
Brian.
Brian.
For the record, the Sunbiz information that is provided to us says Brian PrzYstup. I can't pronounce that, but it sounds like it's Pritztip.
Entonces, según la información que se nos ha brindado, el nombre del dueño es Brian, y el nombre es
Pritztip.
El apellido es Pritztip, ¿es correcto?
Sí, yes.
Yes, that is right.
He's the registered agent and the manager, correct?
Y usted es el agente registrado y el gerente.
Sí.
Yes.
Do you have anything in writing that you can provide the city to show that you have the right to speak on the owner's behalf?
¿Usted tiene algo por escrito que pueda proveer a la ciudad que autorice que usted pueda hablar en el nombre de él? I believe he got first.
Is he frozen or he's just turning to the right?
Señor, ¿me puede escuchar? Señor Alvarado, ¿me puede escuchar?
Hello?
Hola, señor Alvarado, ¿nos puede escuchar ahora?
I guess he can't hear.
Señor, no lo podemos escuchar.
Sí, ni yo no lo escucho. ¿Me puede repetir de nuevo
Mr. Smith.
Do you have anything in writing that allows you to speak on behalf of the property owner?
¿Usted tiene algo por escrito que le dé la autorización de hablar en el nombre del dueño?
No, ahora aquí en la mano no tengo nada. Yo hablé con él por teléfono porque son horas de diferencia, ¿no? Y él me dijo que podía hacerlo, ¿no?
So, well, I do not have anything handy with me. I spoke with him. I spoke with him through the phone, since we have these hours of difference, and he told me that it was fine for me to be here.
Okay, Madam City Attorney or staff, how would you like to proceed with regard to this issue?
Good morning, Your Honor. Assistant City Attorney Vionit Madugash on behalf of the city. Typically, we would require that there be a power of attorney, something in writing. It doesn't have to say power of attorney, but it has to be something in writing that says that the property owner allows this individual to speak on their behalf. But I mean, he says that he spoke with the property owner. I don't know if Your Honor wants to put some weight on that, or you feel more comfortable doing something else with the case.
Well,
if I may, Magistrate, I was just going to add, I mean, I think he says that he's a tenant and that he lives inside the unit. So in this case, I mean, perhaps he's not speaking, he wouldn't just speak on behalf of the owner, but the case, I believe, can still be heard. He may be able to give whatever testimony he can give.
I was going to hear the case with or without him, because It's been noticed, and if the owner chooses not to participate, then that's his problem. But the fact that he's under oath and he's told us that he's spoke to the owner and the owner said it's okay for him to speak on his behalf, I'm going to accept the testimony. But I think we ought to be a little bit more demanding going forward because of issues that may arise if the owner then does not agree with whatever decision is taken. But we'll save that for another time. Sir, Mr. Alvarado, do you understand the nature of the violation?
Entonces, señor Alvarado, ¿usted entiende la naturaleza de la violación?
Sí, sí.
Yes.
Magistrate, I'm not sure if it's necessary, but I think we didn't interpret the last communication regarding the ownership.
Yes, Mr. Interpreter, I stated that going forward, that it would probably be a good idea to let people know that they need to bring a written authorization, whether it's an email or a formal power of attorney or some other legal document, so that there is no misunderstanding later on from an owner who says, no, I never spoke with him.
Entonces, bueno, de ahora en adelante lo mejor sería que probablemente usted pudiera conseguir un escrito que dé autorización, ya sea una carta poder de manera formal, algún correo electrónico o algún documento legal. Esto para evitar malentendidos con el dueño, en dado caso que el dueño comente que no habló con usted.
All right, let's let me ask the gentleman, Mr. Alvarado, how are you going to correct this violation?
Señor Alvarado, quisiera preguntarle, ¿cómo es que usted estaría corrigiendo esta violación?
Bueno, yo fui ayer al City Department, ¿no? Fui ayer y ellos me explicaron los procesos que tengo que hacer, que tengo que conseguir un contratista, ¿no? Para que me apruebe.
Well, I went yesterday to the city department and they explained
un pequeño espacio que nosotros el proceso, porque fue un espacio pequeño, ¿no? Nosotros había un aire acondicionado y lo sacamos porque estaba entrando agua en la habitación y dimos estuco, pero no sabíamos que había que sacar permiso para eso, ¿no? Y por eso procedimos a hacerlo, pero ya lo pintamos, lo hicimos, pero Genaro dijo que teníamos que sacar permiso, ¿no? Y yo fui a la ciudad ayer, tengo todos los papeles conmigo ya para hacer todo el proceso de los permisos, ¿no? ¿Sabes? Tengo ya las aplicaciones para llenarlas.
Okay, let's stop right there because that's a lot to interpret.
So, sí, disculpen, señor. Recuerda que como estamos utilizando un intérprete, necesitamos tener nuestras oraciones un poco más cortas. This is interpreter. I was just explaining to him that since we're using an interpreter, we need to keep our messages a little bit briefer. So, so this is what he said. I went yesterday to the city department. They explained me the process. They told me that I needed to get a contractor in order to get approved. The thing is that in this little space there was an AC that was leaking, and so we were in the need to check out the AC. And once we removed the AC, we'll fill the hole and paint it, and then later we were told that we needed to have a permit in order to do that. And so I have already got all the paperwork and the applications, and I have already filled them out. I actually have them with me.
Okay, let me hear from the city. Show me some photographs. Tell me what is the problem and what recommendations, if any, you have.
Entonces ahorita estaremos escuchando a la persona de la ciudad que nos esté mostrando las fotografías, pruebas, que nos esté mostrando el problema y qué recomendaciones nos estarían dando.
Good morning, City of Miami Co-Compliance Officer Morello. On June 14, while patrolling, I just served the violation where
That's June 14th of last year.
Yes, in 2022. I advised Carlos that I needed to apply and obtain after the fact permit for the stucco work that was done on the front wall of the property. And I made a re-inspection on June 30, 2022. And there was no compliance. Notice to appear was posted on March 2nd, 2023, and also was mailed on March 9. And after my final inspection, there was no application and there was nothing submitted to the city.
This is interpreter, Mr. Murillo. I got the reinspection was in June 3rd. Well, the second reinspection was in June 30, 2022. There was a notification. There was a notification sent, but can you please repeat the dates after
Yes.
June 30th?
March 2nd, 2023. There was a notice to appear was posted, and there was also mail on March 9th. On March 16, 2023, there was a final inspection. There was no permit or nothing was submitted to the city.
Bien, entonces, es el oficial Murillo hablando. El día junio 14 de 2022 es cuando se le avisó a Carlos que necesitaba aplicar él necesitaba aplicar por un permiso después de lo ocurrido, donde después, en junio 30 de 2020, de ese mismo año 2022, se hizo una reinspección. Aún no se había suministrado ningún documento. Se hizo una notificación de comparecencia para marzo 2 de 2023. Esta fue enviada por el correo postal. Después se hizo una reinspección final en marzo 9. Bueno, se hizo una reinspección para marzo 9 y una reinspección final en marzo 16, donde ahí no se tiene que no se había suministrado ningún tipo de permiso o documento.
All right. How much time do you think it will take you, sir, to obtain the permit and legalize the work and fix that stucco area in the house?
Entonces, señor Alvarado, ¿cuánto tiempo cree usted que necesita para obtener el permiso y legalizar el trabajo y finalizarlo?
Carlos, we can't see your face move. Are you frozen?
Señor Carlos, no vemos su cara moviéndose. ¿Está congelado?
All right. If he's not going to be able to respond, let me give him another minute or so because I'm ready to rule.
Bueno, si no va a poder responder, voy a dar otro minuto, más o menos, porque yo ya estoy listo para dar mi decisión.
All right, I'm going to rule on this case as follows. Based on the unrebutted testimony of the city's code compliance officer, the photographs and evidence presented depicting that the cited violation still exists, and proper notice having been given, I find in favor of the city, enter an adjudication, and set an abatement date of May 18th, In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So we're ready to move on.
Entonces, estaré dando mi decisión de la siguiente manera. Basándonos en el testimonio que fue ofrecido por el oficial de código de la ciudad, se muestra que la violación sigue en existencia y que se ha dado notificación de manera apropiada. Entonces, estaré fallando a favor de la ciudad, poniendo como fecha del día de cumplimiento mayo 18. En el evento en que esto no sea resuelto para mayo 18, se estaría asignando una multa de $250 por cada día que pase, hasta que la violación sea corregida.
Okay, is there another case involving the same property?
Oh, it's only 2 cases, which are 6 and 7.
Yes.
Got a recreational vehicle?
Yes, Your Honor.
Okay, this is a single-family home, correct?
Yes.
Okay, so let me hear from the city. This is case number 7, 2022-00249. Go ahead.
On June 14, 2022, while patrolling and observed the violation of a recreational vehicle store on the residential home without a variance. I asked Carlos to please apply for a permit or remove the recreational vehicle. On my reinspection on June 30, 2022, there was no compliance. A notice to appear was posted on March 2nd, 2023. It was also mailed on March 9. And on March 16, 2023, as my final inspection, there was no permit. The trailer was moved to the back, and an extra one was brought to the property. So now there's 2 trailers in the back of the property.
Bien, entonces esto es respecto al caso número 7, lo que respecta al tener un vehículo recreacional en una casa residencial. Caso 2022-0022. Esto se empieza en junio 14 de 2022, donde el oficial Murillo se acerca con Carlos para solicitar que remueva su vehículo recreativo debido a que no cuenta con los permisos o que aplique por un permiso. Se hizo una reinspección en junio 30, no se encontraba en cumplimiento. Para marzo 2 de 2023 se mandó una notificación de comparecencia, que después en marzo 9 se mandó nuevamente por el correo. Para marzo 16 de 2023 hice mi reinspección final, donde se notó que el vehículo recreacional se ha movido a la parte trasera, además de haber traído uno extra, ahora habiendo 2 trailers estacionados en la propiedad.
Mr. Murillo, this has been ongoing since June of last year?
Yes, Your Honor, since June 14, 2022.
Have you discussed this with anyone at the site, at the property?
With Carlos. I spoke with him when I did the reinspection on June 30, 2022.
What did Carlos tell you?
He said he was going to remove it, but then when I had when I went to do the notice to appear, since there was no when I went to post that notice to appear, since there was no permit, I went back to the property, and before posting it, I observed that the trailer was still there, and there was another one. So he moved it from the front.
I wouldn't hold your breath about getting a permit for that recreational vehicle, but go ahead and interpret, Mr. Interpreter. Assuming that Carlos is still on, which I doubt.
Bien, entonces se le pregunta al señor Murillo si desde hace qué tanto tiempo ha estado ocurriendo esta situación, donde su oficial Murillo comenta que esto ha sido desde junio 14 de 2022. Se le pregunta si ha discutido al señor Murillo si él ha hablado con alguien referente a esto de que sea de la parte de la propiedad, donde el oficial Murillo contesta que sí, en junio 30 él habló con Carlos. Carlos dice que él estaría removiendo el vehículo del lugar. Después, el oficial Murillo, al notar que no se había suministrado ningún permiso, fue de vuelta a la propiedad, dándose cuenta de que aún existía que aún el vehículo estaba ahí.
All right, I'm going to enter an adjudication on that one also. But my sense tells me that unless the owner hears about it, nothing's going to get done. So just a recommendation, I would send it to wherever the owner is living in Europe, and hopefully he can find a competent person to deal with these issues, because otherwise that vehicle will remain there, and it's not a good situation. And now we have two. Originally there was one, now there's two, and then we'll see three, and all of a sudden it becomes a storage yard. So somehow, if you could send a copy of the order to the owner, if you could find out where he's living, that would be helpful. But based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication, and set a compliance date of May 18th. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Bueno.
Bueno, go ahead. In case he's listening.
Of course. Muy bien, entonces, en este momento estaré dando mi resolución, donde vamos a estar mandando donde se le estará haciendo la notificación al dueño, donde se le estará mandando una carta al dueño para hacerle saber de la situación, a donde sea que él esté ubicado en Europa, para que consiga una persona de confianza que pueda lidiar con esto, debido a que de otra forma el vehículo estará quedando ahí. Digo que originalmente era un vehículo, ahora son dos, y en un futuro pudieran ser hasta tres, convirtiéndose ya en un patio solamente como un patio almacén. Entonces se le estaría mandando una copia de esta orden al dueño. Y ahora para meter mi resolución basada en el testimonio del oficial de código y en las fotografías y pruebas presentadas de la citada violación, estaría cayendo en favor de la ciudad. Entonces se estaría metiendo una orden de un día de cumplimiento para mayo 18. En el evento de que no se esté en cumplimiento para mayo 18, se estaría sometiendo una multa de $500 de manera diaria hasta que la violación sea corregida.
All right. Move on. Next one.
Item number 10, Bimini Apartments LLC, case number CEMHS 2022-00445, and the officer is Shannon Sanders.
Anybody here on behalf of Bimini Apartments?
All right, sorry, let me remove them. Do we have anybody here on behalf of this property? If so, please click the raise hand feature.
There was a Mr. Barry logged on earlier today. I'm not sure if he's still there.
Barry Shevlin? There he is.
Go ahead.
Barry Shevlin.
I'm here. Can you hear me?
You're there?
Yes, Jose, Mr. Smith, I'm here.
Okay. Just for the record, I've known Mr. Shevlin for years. We have nothing in common other than the fact that we know each other as attorneys. But I don't have a conflict hearing the case.
Mr.
Go ahead.
Shevlin, if you can enable your video, please.
Okay. Okay, we got it. Thank you.
All right.
Special Magistrate, we've known each other for 30 years.
Yeah, and we can tell by the gray hairs, right?
City of Miami Beach attorney and everything else. Very well respected.
All right. Are you still on 71st Street?
No, believe it or not, I'm in Bay Harbor Islands now.
1111.
Yes, sir.
Okay. Let me hear, first of all, let me hear from the officer, and then I'll get... No. Tell me who you are and what is your relationship to the property.
Barry Shevlin. I'm the principal of Bimini Apartments, LLC. I'm the owner.
Okay. And you know why you're here?
Yes, I really don't actually, because all the repairs were effectuated prior to the reinspection date. So I tried to reach Ms. Sanders to let her know that, but everything's been repaired before.
Okay, so this case deals with exit signs, lighting. There's a missing exit sign. I'm going to let the officer go through it.
Thank you.
Unfortunately, I didn't see any photos in the file, so perhaps if there are any showing the signage, I would appreciate it. Ms. Sanders, your turn.
Shanna Sanders, City of North Miami, Co-Compliance Officer. This is a new case for property address 14305 Northeast 6th Avenue, case number CEMHS 2022-00445. I am going to start off with stating, yes, you are correct. There are no photos attached. I recently attached them this morning. I was unable to upload all the necessary files prior to today's date. So that is, I take full responsibility for that, and I do apologize. He is correct in stating that the violation has been abated. Well, I can't say it's been abated. I would like the building official to chime in first and foremost to confirm if permits are needed to replace and or install exit signs. At the time of my initial inspection on June 9th, when I did my annual housing inspection, the exit signs were in disrepair. There were wires hanging out. There were no signs present. As of my reinspection, there are now exit signs there located. So now, again, I don't want to necessarily say the violation has been abated before the building official could chime in and state if a permit is needed indeed to install in or replace them. Otherwise, we can move forward in with some type of abatement in or compliance. But
I can jump in.
Wait, Mr. Shevlin.
Yes,
wait.
Yes, thank you.
There is no violation that signage was installed without a permit. We're asking the building official to tell us whether one is necessary or not. But the fact that the signage is already fixed, corrected, meets the requirements of this particular code violation. Now, if it was done without a permit, then I'm sure that I'll see you again in the future, unless you're agreeing to go out and get a permit. It all boils down to what the building official says is necessary with respect to the placement of an exit sign. Tell me, Mr. Building Official, is one necessary or not?
No. Good morning, Mr. Magistrate. No, one is not required unless if they're adding more fixtures, then I would say yes, come in and to bring it in. But I guess it's just a matter of maintenance. That's basically replacing one exit sign with another, right? Correct, Mr.
Shevlin.
Yeah, I actually got on the ladder myself. I painted around it, and then I put it up myself. Okay. I took care of it, Mr. Building Official. I'm good with my properties.
Okay. So let's do this, Ms. Sanders. You go out there and make sure that everything has been done to your satisfaction. I'm going to table this case until May 18th. If everything has been done to your satisfaction, the violations will be dismissed. If in your opinion there's no compliance, there hasn't been any compliance, then you can bring it back on the 18th and we'll hear it again. So we'll handle it that way.
Sounds good to me.
If I may, she's already been out there and she said she re-inspected and everything's fine. She was only questioning whether it needed a permit or not.
Okay, you're right. Are you prepared to dismiss the case, Ms. Sanders?
I am.
Thank you.
All right. So case dismissed. Have a great day. Good
Thank
seeing you again.
Great seeing you again, sir. Thank you so
Bye.
much. Bye.
Next case.
Case is item number 13, Ethan Zimmerman, case number CEMIS 2023-00143-141. And the officer is Jose Torres.
Mr. Zimmerman, if you can enable audio and video, please. Magistrate, I just have a quick question for clarification's sake. I think that's probably one of the first and few times we've seen a property owner / attorney. Would it be presumed that because he's an attorney that he would not need to be under oath? I mean, in that circumstance, he owned the property and the violation was against the property. Is it assumed just because he's an attorney that he doesn't need to be under oath, or how does that work?
Well, it's a little odd because he's both a property owner and the attorney. As an attorney, he doesn't have to be sworn because if he makes a misstatement or a misrepresentation, he'll be in trouble with the Florida bar and may even lose his license. So as an owner of property, and I believe that he wasn't even an owner. What case number was that?
Number 10.
13.
Okay. All right. So he really wasn't speaking as an owner. He was speaking as the manager member of an LLC.
Okay,
so,
I got
you. He represented himself as the owner. So I'm satisfied that if he made a representation, even if he wasn't sworn, if it turns out that he's lying, then the Florida bar will deal with it. Well, we don't typically swear in attorneys.
Right.
He did say that he got up there and he did it himself, which my question was, do you need to be an electrician to do that? But probably not.
Right. Okay, I just was, again, it's not common that the council is also the owner of the property, so that was a little bit of an interesting dynamic.
Yeah, I would have the same concern, but being that he's an attorney, his statement is deemed by the Florida bar to almost meet the requirements of being an oath. So that's why attorneys are not sworn. And I imagine him as the attorney for the property. So I'm glad you brought it to my attention. We'll keep it in mind next time the issue comes up. But nonetheless, if the officer has a chance to go by there again and make another inspection just to make sure that everything has been done correctly, just to be safe, that would help.
Thank you. Clerk, if you could swear Mr. Zimmerman.
Mr. Zimmerman, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
You're muted, Mr. Zimmerman, if you can unmute.
Sorry. What case are we hearing?
I do.
What case are we hearing? Number 13?
Number 13.
Okay. Mr. Zimmerman, for the record, again, tell me who you are and your relationship to the property.
My name is Eitan Zimmerman. I am the property owner.
Is this property that you own at 13005 Coronado Terrace a single-family home?
Yes, sir.
And do you understand the charges being brought against you today?
Not exactly.
Okay. You own a boat?
Yes, sir.
You do boat charters?
No, not out of the property, sir.
Okay. Do you have well, let me first half of the city present its case, and then you'll have a better understanding of what the charges are about.
Sure.
Mr. Perez, you're a good officer for this particular case because I know you like boats.
Good morning, Jose Perez, co-compliance manager here with the City of North Miami. Today we're hearing the case. It relates to the property at 13005 Coronel Terrace. This is in reference to boat charter activity. So this case, unfortunately, we have several complaints from various residents as it relates to not only the traffic and the sheer amount of volume of people coming in and out of the property, but we also have advertisements for the actual vessel, My La Grande Blue, which is an Azimuth 66 fly. As you can see here, the picture that's in the screen right now, this is a direct screenshot from a website where it's advertising the charters on the there's a page a little bit down. There's a screenshot of the actual vessel. At the rear of the property, you can see it's La Grande Blue. It's towards the end. There you go. That is the vessel that's being advertised, the same exact vessel. And we have several, not only videos, but photographs of various residents and just customers in general being dropped off at the property. Therefore, it is very evident that chartering is going on at the property itself. At this point in time, the violation was originally opened back in January of 2023, and unfortunately, the activity continues to the point where police have been involved as well, and they've been out and responded. I've been working with Marine Patrol as well as it relates to this. Here we have a video, for example, that shows customers being dropped off, going in through the side of the property, going and basically getting ready for this charter activity that's going on. And
what's the date of that video?
The date of this video, as a matter of fact, 1 second.
I saw one for January 27th and one for January 29th. I saw two videos in the file.
Yeah, so
that's one of the ones I saw.
Yeah, excuse me 1 second while I pull up the actual dates. This one's from January 29th of 2023. The video we saw first was from a later date. I'm trying to pull up that date right now as we speak. 1 second.
And I see people carrying luggage with them.
That is correct. So the previous video that we saw was from March 1st, 2023. And this is all the evidence the city has. As I mentioned, the activity is going on, and we're getting several complaints. This is again on January 27th. More people with luggage getting ready to go on the charter. So at this point in time, the city is not only asking for an adjudication, but we're asking for a monetary fine, as this act in nature has been very bothersome to the neighbors. It's disturbing the peace, and as some of the emails that were seen in the case, they're not very happy about what Mr. Zimmerman's doing in his property.
Sir, this is not a joke.
What he said, what the claims, Your Honor, with all due respect, the claims that he made were unsubstantiated and false, and they can easily be refuted and verified that what he's saying is wrong. For example, I own that vessel with a longtime friend. The video that he's portraying to be a charter is verifiably my friend and his family taking the boat that they own with me out on a trip. To portray that as a charter is a little bit disingenuous. I don't appreciate it as if it's stated fact when in fact it isn't.
What about the advertisement? Doesn't that mean anything?
The boat is, Your Honor, the boat is 100% advertised on the internet. I will not deny something that is true. However, the charters We have receipts. The charters take place out of Haulover. We have to pay a company. Now, if there's something wrong with that, I would respect your ruling, and I would respect the rules to stop doing something that's not allowed. However, clients do not get on the boat at my house, nor do we accept any money for people that get on the boat in North Miami and Keystone. We just don't allow it. So we have to pay $325 to rent it's like a little mini charter out of Haulover. So anybody who does pay to use the boat parks at Haulover Marina. We have to shuttle them from Haulover out to, 100 feet offshore of Haulover. They get on the boat. They do whatever charter that is that they're doing. They get dropped back off at Haulover. We instituted this the first time that anything was brought to our attention. Nobody ever called us. I randomly received at another address a code compliance, and the only action item on that letter was to cease charter activity from that address, which we immediately did. Immediately. Okay, I live 5 minutes away, for example, Your Honor, and I'm 100% in compliance with what was requested of me. I live 5 minutes away. I live in Bal Harbour. My parents live at this house. My dad had a stroke. We moved him out here for the weather from California. He loves the boat. And the same neighbor, by the way, I can tell by the vantage point of the video provided both, the same neighbor started screaming at us for illegal charters. Why? This is last week. Why? Because I took my family out last Sunday on the boat with friends, and my parents were out of town. So how could that boat be used by the people that live there if those people are out of town? Little does that neighbor know that, one, I own the house. The title's solely in my name. The mortgage is paid solely by me for my parents. And two, the boat is in my name, and I can use the boat whenever I see fit. And for her to come out and start screaming that it's an illegal charter when it's my boat at my house, it's setting this narrative with code compliance who doesn't, they have to go by the neighborhood and by what people say. But unfortunately, it's not true. It just isn't factually what is happening. And it's very frustrating because I have no way, I haven't been presented until this point, any ability to provide any information or anything to say, well, no, that's not accurate, or this is the first time months into it where I have the ability to explain the situation. If I'm doing something wrong as it stands today, I will 100% fix it based on whatever you say I need to do. However, I don't know what that is.
Let me stop you, and then we can move on to another subject. Do you have a captain's license?
No.
Don't you need a captain's license?
I'm not allowed to captain the boat. It's too big.
So do you have a captain?
Yes, we have 3 captains that whenever we want to go out, I have to have the captain with us too.
Okay. Do the captains have a Coast Guard license allowing them to do charters?
If the captain ends up doing a charter, yes. They also have proper insurance to do charters.
I'm not questioning the ability for you to do charters. The issue here is the unpermitted use of a single family residence in North Miami to be used as a pickup and drop off point in the operation of this activity. Which by the way, if you look at your advertisement, it specifically states your house address.
I don't believe so, because the people don't go there. My parents live there. I don't want people going to my parents' house. I mean, it's my house that I've given to my parents to live at. I don't want people going there. I have the receipts. Like I said, I have the receipts at Haulover. We go to a great expense to follow what code compliance requested, based on no conversation, but just something in the mail. We have to pay a company to charter people from Haulover parking out to the boat in Haulover.
And those receipts are evidence of what?
that we don't pick up people at the house, I guess. I mean, it's hard to prove. It's hard to prove something where there is no real evidence. Otherwise, I mean, are there receipts of people paying at the house? The video that I saw happens to be a dear friend of mine, David Schottenstein, and his young 3 girls taking their suitcase after they took a trip to Palm Beach. It's just.
Oh, the people that came to your house, you're telling me, are friends of yours, Mr. Schottenstein, and they brought luggage.
Initially, Your Honor, listen. Initially, there were paid charters out of that residence, 100%. There was probably 6 of them. We received a letter in the mail that said, you can't do that. We're new. We didn't know. We purchased that house just a couple, maybe 10 months ago, 12 months ago for my parents. We had no idea. The point of the charters was to offset the cost of the vessel for my dad and for myself. That was the point of the charter. It's not a business per se. So as soon as we received the document from Code Compliance, I said, well, that's done. I have no interest in getting into any problems. We can't do this. So we looked at alternatives. The alternatives were a company that charges $325 per trip. In Haulover, they have one of the slips at Haulover that are hard to get, and they shuttle the people back and forth, completely stopping any paid activity whatsoever at the residence at 1305 Coronado Terrace. Completely stop it. There is
you say they shuttle the people from Haulover to where?
To Haulover. Just the boat doesn't fit in the slip. The people park. They get to the slip with it's a small, let's say 25-foot a tender, and then it drives them out to just outside of Haulover, the Intercoastal. They get on the boat in the Intercoastal. They go do whatever they're going to do, whether they're going to go down to Key West, whether they're going to go around. It doesn't matter. Whatever it is they do, they get dropped back off at Haulover. The tender comes back to the Haulover right off coast in the Intercoastal. It puts the people back on and drops them back off at Haulover. And it was recommended to me, just to be honest, it was recommended to me that, no, it'll be fine. You don't have to do that. It's a lot of money. And I said, I don't do this. This isn't my business. I'm not doing this for business. My dad loves having the yacht there. He loves going out with the captain. He does lessons on the boat. He loves it. It's for him. I'm not going to say it's a beautiful boat. Unfortunately, and I think another aspect that happened here is just like anything, as soon as you get almost a 70-foot yacht, 2016. A lot of friends come out of the woodworks, believe it or not. And when we first got the vessel, I think it was probably January, there was a lot more people coming to the property. Most of them did not pay $1. They wouldn't even pay for the hourly, meaning it's very weird to tell your friend, oh yeah, you can take the boat, but pay the captain $1,000. So we were paying the captain out of my pocket. Like I was taking care of those payments. And obviously that dried up and people aren't, calling me, oh, I heard you have a boat. I heard you have a boat. But as far as this code specifically, as far as this violation and the situation, I guarantee if what I explained to you is not in violation, then we are not in violation. There is not a single vehicle that is parking in Keystone in North Miami, in our parents' house, in my parents' house. There's not a single vehicle that is paying us to rent the boat and using the address in North Miami as a kickoff point or jump off point of any paid charter whatsoever.
Okay, Mr. Zimmerman, I saw people walking with luggage. Where did they park?
They parked. If you look at the car, he parked right behind my dad's truck. It's the black BMW. It's an X7. That is my friend who paid $0. Not only my friend, he owns half of the boat. I own half. He owns the other half. That was his family.
Okay, and how come the vessel is not docked in Bay Harbor? Did you say Bay Harbor or Bal Harbor?
Bal Harbor. Bal Harbor. I'm not that rich.
Well, to live in Bal Harbor, you can't be poor.
There's a large gap between a dry lot and a wet lot. I'll tell you that.
Okay. So you have a dry lot in Bal Harbor.
Yes, sir.
And that's why the vessel is in the other property.
Yeah, so my in-laws own the house next door, and we have a small 22-foot boat that was, family use. Same thing. Like, I totally respect the neighborhood. I respect the rules. As soon as we received that document, and I don't remember the exact date, but I received it in the mail, and all it said was action items to satisfy. The action item was specifically cease any charter operations out of the address. And I immediately complied. And I said, okay, so you can't do this. Fine. Let's find an alternative. And since then, there has been zero paid charters leaving that property. And I guarantee under oath, there will be zero paid charters leaving my parents' house moving forward. It's just not an option.
Okay, is the scenario that let me rephrase it. I saw videos on that were taken on January 27th and January 29th, and then I heard the code officer say that there was another video on March 1st. Are you telling me that the original videos represented the basis for which you got a letter saying stop doing this? And if you stop, what is in the March 1 video that reflects one way or the other whether or not there was any chartering going on?
Sure. So I can't tell you exactly the date. I don't remember when I received the letter in the mail. What I can say is that video, for example, they're all coming from the same neighborhood. As soon as we received notification and the solution, or the remedy, thank you, Your Honor. The remedy was to cease any boat chartering operation. We then ceased. And I have no intention to ever do a paid charter. Now, my partner, who owns, it's not a partner, we co-own a boat together. He has the right to use the vessel just like I do. He doesn't charge, meaning he can't initiate a charter out of the house. But he also has parents, and he lives here in Surfside. He also uses the boat, the video with the luggage. That's him. That's his vehicle. The license plate could be tracked back to him to verify everything that I'm saying is not made up. Those are his children, his 3 daughters. He also has the ability to use the vessel. And I mean, I understand, if the neighbors have a problem, I'm not of the opinion, go fly a kite. If there's something that I'm doing that is wrong or that is bothering them, I would be I'm all about a remedy. I just don't know within my rights as a landowner and a property owner what I'm supposed to do at this point.
Okay, it's very simple. You live in a single family residential neighborhood, no different than living in Bay Harbor or Bal Harbor or Miami Beach. And there are certain prohibitions that are applicable to single-family residential neighborhoods. And operating a business of boat chartering out of a single-family neighborhood is not a permitted use under the code. So you can invite your friends, your family, your father, your next-door neighbor, and that's okay. But what you can't do is engage in a boat charter business from a single family residential neighborhood. It's that simple.
Crystal clear, Your Honor. And a note, when the code enforcement officer said that the police were involved, okay, the police came out because the same neighbor that took the video called the police for parking enforcement because we were on the boat and I had some friends on the boat. And the police came and the police said to us, everything is fine. You're parked legally. And they left. So it's I don't like this. Believe me, I don't like this. Like I have my own company. This isn't my job. A lot of what's being represented is just it's a little bit of a stretch, and for lack of a better way of saying it, is it's just untrue. Not on purpose. I don't think anybody's trying to misrepresent the truth. I just, you have neighbors calling, screaming, like it happened to me last week, screaming at me. The only reason, just a little bit of extra, I don't want to keep taking your time, Your Honor.
Yeah, we're going to have to cut this. Yeah, we're going to have to cut this short. Yes.
Magistrate, if I may, I just wanted to, I think that, the property owner has admitted to chartering from the property. Whether or not he's still doing it is up for debate, but I think that he has identified that the charters had happened. The city would request that your magistrate would consider a one-time fine. Further, I think that the property owner should consider the fact that, and to your point, magistrate, that if the boat is still being moored at the property and the advertisement is still live, there's it's natural that your neighbors are going to presume that you're still chartering. You've already admitted that you've chartered. The boat is moored there. The ad is still live. I mean, this is going to probably be a bit of a, there's some ambiguity, naturally, given the circumstances. So, for sake of time, magistrate, the city would ask that you would issue a one-time fine regarding the matter. Okay.
Let me say this along the lines of what Ms. Patterson is suggesting. I think what you need to do, Mr. Zimmerman, number one, is pull that ad, or if you're going to advertise, if you want to make some money to pay for the cost of that vessel, and believe me, I know how much it costs to maintain a vessel like that. Just insurance alone is probably $20,000 a year, plus fuel, plus whatever. You need to be sure to include in any advertising that there will be no pickups anywhere in the city of North Miami.
100%, no problem.
And that any pickups will be only at Haulover Pier. By the way, I was there at Haulover this past Sunday, and I know how many charters are there. I can tell because when you have 25 people on a boat your size, to me it looks like a charter.
Right. I mean, we don't allow more than 11 on the boat because it is for personal use, and we don't want it destroyed with
I don't, and I wouldn't either. So number one, that advertisement is not appropriate in the sense that it may encourage people in your neighborhood to go there for a charter, especially if on a Sunday afternoon you're going to do a charter. And they live nearby, they're going to go to your house and they're going to get on the boat instead of having to drive all the way to Haulover.
May I ask a question, if I may?
Quickly.
Where's the address? That's the part I'm fine being very clear that all pickups and drop-offs happen at Haulover, but is the address listed? I don't believe the address is listed anywhere.
But that's the ambiguity that I'm referring to. So the fact that there is no address creates the perception that because the boat is moored and docked there, that's where the charters are happening. Specifically, you guys have that paved walkway on the side of the home. And, whether it's friends, family, whomever, again, the perception is that, these are people that are paying for a charter service. And
that paved walkway was there when we bought the house a year ago. But I understand. I mean, I understand. Nobody knows to show up there because the address isn't there. But I will make sure that any advertisement of the vessel clearly in capital letters states that any pickups and drop-offs must happen at Haulover.
Okay. Now, if your friend, your cousin, your next door neighbor wants to join you on a fishing trip, that's okay. What's not okay is charging for the privilege of getting on your boat unless they're doing it out of Haulover.
Understood, Your Honor.
Okay, so I'm going to give Mr. Perez a chance to rebut. And please, Mr. Zimmerman, I've heard from you. I've given you a lot of leeway, and now I need you to be quiet so I can hear from the city.
Yes, sir.
not to make this any longer than it has to be, but I'm pretty much going to reiterate what Director Patterson advised. Basically, that the charters did take place at one point in time. Mr. Zimmerman did admit to that. So at this point in time, really, the position the city's taken is for an adjudication as well as a one-time fine for the charter activity that did occur, which we feel that would be fair. At this point in time, really, the city has no further commentary for this case.
Okay. So, Mr. Zimmerman, this is my ruling. Based on all the testimony that I've heard, the documents presented, the videos, everything else, your testimony, I find that there has been a previous violation for which you conceded, you didn't know better, but nonetheless, it is a violation, and I know that you testified that you have stopped that. Those activities that were deemed to be violations of the city code. So I'm going for those violations that happened in the past that you were not aware were violations. I'm going to fine you $1,000, and I'm going to further say that if this comes back if it comes back, the fine, I'm telling you right now, is going to be the $5,000 fine that is provided for in the code for violations that are irreparable and irretrievable. So you've taken a lot of our time, and that's fine, because I wanted to make sure that we did justice and that we be fair. But to resolve this matter, you know what you need to do. You're going to be fined $1,000 for those prior violations. We're not going to impose any further fines at this point unless we find additional violations going forward. But now that you're in compliance, the city is satisfied that at the present time you're complying with the code.
The last thing, Your Honor, can I get the pictures just so I can make sure we can track them down and make sure that the pictures are removed that do show the property or the boat at the property? I want to make sure that gets taken care of.
Mr. Perez is going to provide those to you by either email, or you can go on the city's website and look them at. There's a website where everything having to do with your case is listed. And if you look at today's agenda, it's item number 13, and there are about 4 videos that are shown there, along with the pictures of the boat, the advertising, and everything else.
Thank you, Your Honor.
Okay, thank you, and let's move on. Good result, everybody. I appreciate your cooperation.
Thank you.
I'll proceed with item number 33, Richard A. Basola, case number MHVIO 2017-00761, and Mayor Jin will be the one to present this case.
I'm sorry, is it Richard Crystal?
No, he's here in person.
Oh, okay.
Is that Richard Basola?
They can hear you now.
Can I speak?
They can hear you now. They're going to speak.
Hello, I'm here.
Hold on. We need to see his video, Alex, please.
I need somebody to help me. I can't see and hear.
We can hear you, sir. Just a moment. Thank you.
Richard, please raise your right hand.
You talking to me?
Yes, please raise your right hand.
What's the say?
I have no idea you're listening.
Raise your right hand.
Raise his right hand.
Raise your right hand, Richard.
You need to be sworn, sir.
You're okay in there?
I can't. Who's talking to me? I don't understand what's going on.
They're asking you a question on the mic. Can you hear on the mic?
I hear. Who? What is the question?
Raise your right hand.
Raise your right hand is what they ask.
What's my what?
Raise your right hand.
Okay.
But if you can't hear, they can't help you.
I'm raising my right hand. Now what?
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God, you say I do?
Yes, I do.
Sir, I'm the special magistrate in today's hearing. And first of all, can you hear me?
Now I can barely, yes. Go ahead.
All right. I'm the special magistrate, and my question to you, sir, is what is your relationship to the property at 1570 Northeast 141st Street?
Yes, I own it.
You're the owner.
Yes, it's in my sister's name and my name by a will my father and I prepared years ago.
Okay. Are you living there right now?
Yes.
All right. Do you understand that the city has decided or determined that your house is uninhabitable?
I've talked to him about it, but I've tried to talk to somebody 100 times and nobody goes over these items with me. I can't see to read this stuff because I'm a Bascom Palmer patient. I just had eye surgery in both eyes and lasers and all that kind of stuff. I wanted somebody to come out here and sit down and talk to me simple English and loud and clear so I understand what to do. The only thing I know is I had some roof leaks, some drywall damage from the roof leaks, and some floor damage. And they complained about some electric wires. The electric panel door was off. So squatters had gotten in my house and was trying to steal the air conditioning unit. They took the panel off. That's the only thing. There was no electric been done. And so somebody told me to get a permit. So for what? I don't know. You don't need a permit to do repairs, replace drywall and stuff like that. That's repairs. So I went down to the city. I got a ride. Somebody took me to the city. And they was there all afternoon. They filled out a permit application and had me sign it. Then he wanted my ID. So I gave him my driver's license. He says expired. I said, I know, I'm a Bascom Palmer agent. I can't get it done until my eye work is up to that. I'm being treated for that. So I had to go to my regular doctor's appointment. Now I've been with them over 10 years. And they did all my paperwork, and I signed all the stuff for prescription stuff, and they notarized my application. And I sent somebody down with the application, and they said it has to be notarized by a city notary. And I said, not that I know of. And, I was a notary before, and we didn't have to have special privileges to sign the affidavit because my medical doctor's office had notarized all this stuff. So I don't know. I can't talk to a real person. I keep getting a computer.
Well, you're going to be talking to a real person right now because the code officer who is involved in your situation is here and will testify on behalf of the city right now to explain what's going on.
Okay.
Mr. Building Official, is that you or Mr. Beswick?
No, it would be me, Mr. Special Magistrate.
Okay. Before you start, I note that this goes back to 2017.
Correct.
Tell me why the prior building official determined that the premises were uninhabitable and whether or not you agree with it.
My predecessor, Mr. What's his name? Brazillo, building official Brazillo. Then I guess opened up an uninhabitable case in June 26, 2017. I recently visited the property and saw for myself the conditions in which the property was in. So, but this case is for the 2017 case, and at the time from 2017, I could not view any photos, but I could only testify for what I've seen recently at the property.
What is the condition of the property today?
Okay, so for my visit, I visited the property. I got a call from Code Officer Tamara. Regarding a possible unsafe condition. During my visit to the property, I observed exposed live electrical wiring, a damaged electrical panel, deteriorated roof framing members, loose and potential falling ceiling, drywall, and a deteriorated flooring and floor supporting members. At that time, the North Miami Police and myself spoke to Mr. Basolo at length regarding that. Soon I'll place an unsafe structure for his property. On February 17, 2023, I posted the unsafe on his property, giving him 72 hours to vacate the property. At that time, I opened up another unsafe case in addition to the one here in 2017. On February 22nd, 2023, I communicated with Commander Maycock with North Miami Police, and he mentioned that DCF did come out, but Mr. Busolo refused to go with DCF. And also on the February 23rd, 2023, Mr. Richard Busolo submitted a permit application as an owner builder to try to address these concerns, but the permit application itself was incomplete, and along with his driver's license being expired. So I sent him a letter saying that I'm going to reject the permit application, and I mentioned to him several times that he needs a contractor for the electrical work, and also he has the structural structural elements that he needs to address. So we talked another time, and he talked to staff. There was a time he called the office, probably 20 minutes on the hour. Myself and the city, I mean, we did everything we can to try to see if Mr. Richard Busolo could obtain a permit, but unfortunately, he does not have sufficient documents for a permit submission and even approval at this time. My last resort is
Richard Busolo doing this as a city authorized representative, or is he doing this out of the goodness of his heart, trying to help this person out?
Sorry, Special Magistrate. Can you say it again? I didn't catch.
Yeah, is Mr. Busolo now working independently and filing building permits?
No. So my predecessor opened the case back in 2017. So Mr. Busolo is now with another municipality, so he's no longer associated with this.
Okay, so who's overseeing the permit application right now?
Well, we helped them fill it out. Some staff member helped them fill out the application, but he does not have sufficient documentation in order to process the permit application.
Well, even if he did, does he have the means and the resources to do the work necessary to make this house habitable?
From what I see, I don't believe so.
So you're spinning your wheels with paperwork. You know, you're the authorized representative, and you're given authority by the state, by the county, by the city. Once you declare the property unsafe structure, you know, he's got to leave. I hate to say it, but you know, if DCF is not handling it, who else would enforce it?
So I've taken measures to submit this case to unsafe structures. So we're basically trying to exhaust all methods in order to resolve this case. So he's refusing to leave the premises. So.
Can I say something? Sorry for the noise. They're setting the alarm right now, but per the code, I know that the building official, you told him that he has to leave. You can temporarily secure the property, and if the city manager needs to be involved and has to repair the property, then we can charge the property owner and he can pay us back. But that's an option that we have available to us per the code. I know there's different things that's been going on, and we have to exhaust some administrative remedies and really give him a time to appeal the building official's decision. If we don't do that, then we face another obstacle. But I just wanted to bring that up. So,
well, from my reading of the code, there is an unsafe structures board in the city of North Miami. Is there not?
Yes, there is. But what I'm saying is that if the building official determines that the property can be made safe by the property owner getting permits and bring the property up to par, then there are different avenues that can be done and not have to go in front of the board.
Okay, well, those items are not within the realm of what I have authority to do. You know, my ruling would be that the city of the building official has all of the authority necessary to carry out whatever needs to be done. And I hate to say it, but you know, you don't want this gentleman living in a building that is about to collapse, and it's been declared an unsafe structure, and that has a meaning. And the city is the building officials' finding trumps anything that I could say on it. And so, if the city has the ability to help the gentleman out through whatever process, you know, fixing and then putting a lien on the house or whatever it is, that's not within the realm of my authority. All I can say today is, you know, basically approve the determination of the building officials, which is really a ministerial position, because I can't even tell the building official what to do. But I concur with whatever the building official feels needs to be done right now. And if you want to refer that to the city manager for any equitable remedies that may exist, that's within your authority. So there's nothing more I can do. I mean, I can fine, you know, I can fine the property owner $1 million, but that's not going to help anything.
Yeah, Your Magistrate, I think just for, you know, for all intents and purposes and clarity's sake, we definitely, you know, want to ensure that, I mean, we just have something from the city's side, from Your Magistrate. We would have to go to the county to pursue the unsafe, you know, the formal unsafe structure ruling. But we definitely wanted to just have something from Your Magistrate to satisfy the city's code as it relates to the matter, and then, you know, move forward with, you know, we recognize and we are aware that a lien would not resolve this matter. We are also in talks with, you know, our social services offices and, you know, even perhaps, you know, some other entities to see what assistance is available to assist in remedying the issue. But I think we just wanted a formal ruling documented to support the case that we have to take.
Yeah, I understand. The only thing I take issue with, because I just went through this with the city of Miami, if you have your own unsafe structures board, you don't need to go to the county. You do. We don't.
We don't. We're currently using the county. Yeah.
Oh, okay. I thought you did.
Correct.
Okay, then you need to go there, and then they need to affirm the building official's determination that this is an unsafe structure, and then you're covered. And you know, my decision again is that I concur with the building official in his determination that this is an uninhabitable building. It is an unsafe structure, and it needs to be demolished.
And Mr. Magistrate, just to clarify, the element that makes it unsafe are the wire, the electrical wiring. You know, he has these basically service wiring coming from outside to feed the panel, and those things are just exposed. You could just see the lugs and
but you mentioned 5 or 6 other issues.
Correct.
So even though individually they may not by themselves constitute an unsafe structure, when you combine all of those deficiencies and defects along with the electrical issues, it is clearly an unsafe structure.
Correct.
When can I talk?
All right. What is staff? Is somebody going to get back to Mr. Bazzola and explain what just happened?
Well, what I'd like to do is to tell you my side, okay? What they came to the house for, I was in the middle of taking down some damaged drywall and ceiling tile. When these people showed up, they went around, took away, and somebody said something about unsafe. And I asked them, called a bunch of times to the building department, trying to get someone to come on and tell me what's unsafe, because I'm a certified general contractor a lot longer than the building department has been. I built all over North Miami, Keystone Point, all the way up to Palm Beach and back. I just built a castle in another state, so I know what is unsafe and what is safe. And I just wanted somebody to come out there and show me what they're talking about. And nobody would even answer the phone for me. They put me on hold and I get cut off.
Well, I just heard the building official spend about 10 minutes outlining everything that he found wrong with the property as of today, not 2017.
I don't know anything about
2017. As recently as probably the last few days, he's talked about electrical issues. He's talked about drywall issues, flooring, exposed electrical wiring, and on and on and on and on. So, I mean, if you're a general contractor, sir, and you have exposed wires, isn't that an unsafe condition?
Well, let me explain it. I told you I had squatters in my house. They were trying to steal the air conditioning. They stole some motors out of some stuff in storage, the electric motors, because the copper in them. They're stealing it for the scrap. All they did is they took the panel off. They were to take the air conditioning motor off. My neighbor is across the street, runs a Metro Rail. He's an electrician. He came over there before and helped me hook it up when they tried to steal the stuff before. Well, now, I'm in and out of the hospital the last couple of years here with my medical stuff here. And the wires he's talking about, I asked him to come out there and point out to me exactly what he took, because all it was the electric panel off. They put the panel on and you don't see those wires. All he saw is the wires.
All right, we're going to stop right there, sir. And somebody from the city is going to contact you to see how they can be helpful to you. There's no guarantee that anything will be resolved today, tomorrow, or the next week, but somebody from the city will be in touch with you to discuss the next steps.
I agree. That's all I ask. I'll fix it. I'll fix it in a heartbeat.
Mr. Magistrate, the building department exhausted basically all their efforts. I even dropped off a packet with photos and a letter of rejection to Mr. Basolo. So there's nothing further for me to tell him. The only thing I can tell him, just, if he's able to find someone, a contractor, to basically try to get some type of quote to engage a contractor.
I think that would be a waste of time. Okay. I think what needs to happen, as we discussed earlier, is you need to go to the county, let the county issue an unsafe structure order outlining everything that is wrong with the property and giving him whatever time he needs, maybe 30 days, maybe 60 days. They will do that.
Okay.
As you well know, I mean, when you go in front of the Unsafe Structures Board, they're pretty thorough, and it's a very good board. It's made up of about 15 people, engineers, contractors, design professionals, and they will be ordering whatever they feel is appropriate, and then he can deal with them instead of
I have a question. If the city of North Miami would just come out and walk around with me, point out what they want to be done, I'll be happy to do it. The squatters cleaned out my bank account last month. I had the guys come down to do work on the house.
I hear, sir. I hear what you're saying, but the building official says that they've done everything they can do for you, and they can't go any further.
All I ask is somebody to walk around and point out what they're talking about, because I can't read.
If you as a contractor don't understand what the building official just explained to us, then I can't trust you to do the right things. Okay.
I built all over North Miami.
I know you did.
Anything turned down.
But you're not taking care of the house, and that's the
problem.
It's not
that. I had squatters in the house. All I want is a building inspector to come out and point out what they're talking about. I can't read the letters because I had the eyes.
I'm sorry, sir. I think we've given you enough time. Somebody will get in touch with you and explain to you what the next steps are going to be.
That's all I want.
Okay? All right, that's it. We're done.
Magistrate, just to confirm, there's no adjudication on this property?
As far as fines are concerned, the answer is no. My ruling is to basically confirm the findings of the building official, the building department, and I find that based on what I heard, the building is unsafe and it is subject to demolition. And the next steps, I suppose, is getting the Unsafe Structures Board of Dade County to issue a demolition order, and then the city will go out with its resources and demolish the property. That's the process. That's how the process works, and I'm in support of that process. But in terms of fines, I don't think imposing any fines is going to be helpful here.
Yeah, clerk. So just for clarification, I just want to make sure she's clear that there are no fines, but it is, but he has adjudicated and found in favor of the city regarding the unsafe structure.
Noted.
Okay.
It's not unsafe. They haven't pointed anything out to me yet.
Okay. Well, they will report it to the Unsafe Structures Board, and they will decide.
In the meantime, can you ask the city of North Miami inspector to come out and walk around with?
I can't order him to do that. That's on his own. That's on him. If he feels it's helpful, he would. If he feels it's a waste of time, he won't.
Okay, may I go? Should I go next door to the building department and ask for somebody to walk?
You can go to the building department and talk to them if you want, but
I can't get them on the phone.
No.
Well, I don't think it's going to, at this point, sir, I don't think it's going to do any good.
The structure is not unsafe. I'm trying to tell you, but that's why I want to have another official there to just walk through.
Well, I have determined that it is unsafe based on the testimony that I heard. So
I'm telling you, it's not unsafe. My word is as good as their word.
Sir, I ruled that the property is unsafe based on what I heard. Case over.
Yeah, but tell me what's unsafe. Nobody told me yet.
Let's move on to the next case, please.
Item number 19. We have Ernesto Pesola, Apindukai, and Maria J. Monreal Rivero. Case number CEZPU 2022-00109, and the officer is Jose Perez.
I have Ernesto Pesola. Ernesto Pesola, are you there? Ernesto, if you can enable your audio and video.
Hello.
There we are.
Sir, please raise your right hand.
Raise your right hand, sir.
Yeah.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Do you need an interpreter?
Yeah, maybe it's better to understand very well.
Nice interpreter.
Sorry for that.
Okay, sir. I'm the special magistrate that's going to be hearing your case today. I understand that you have been charged with operating charters and advertising for charters out of the home at 2055 Arch Creek Drive. Do you understand that?
Yes, I understand.
Okay. Do you understand that that is a prohibited use under the city code?
Yes, I just viewing the last guide that do charters, so I can understand a little more this. But the notice that I got is tell me about another people or another company is that mentioned in the letter, I think.
How long have you owned the property?
2 years and a little.
You have a boat?
Yes.
What kind of boat is it?
I have an Azimuth 64.
How big is it?
64 feet.
Okay. And it's docked at the property address?
Yeah, it's my house. I am the owner of the property.
Okay. All right, let me hear from the city.
Morning. Jose Perez, co-compliance manager for the City of North Miami. Today we're hearing the case in regards to the property located at 2055 Arch Creek Drive. This case is as it relates to boat chartering. At this point in time, there are several advertisements that depict a company, TLM Marine LLC, chartering from the property at 2055 Arch Creek Drive. On the advertisement itself, off of Groupon, it says that the departure point is specifically 2055 Arch Creek Drive, as well as the vessels that are being stored there. We ran them with Marine Patrol. They came back to TLM Marine LLC. So we confirmed that the vessels being advertised are being docked at 2055 Arch Creek Drive.
I'm sorry, let me stop you for a minute. Jose, 1 second. Are there more than one boat? Is there more than one boat or one?
Yes, there are two
He mentioned
vessels.
one. How many are there?
There are two vessels stored at the property. Both of them are registered to TLM Marine LLC.
Okay.
One is a Regal and the other one is a Sea Ray.
Is the property owner the owner of the vessels?
They're registered to TLM Marine LLC. So if he is an agent of that corporation, then he would have association with that.
We don't know that. Okay, keep going.
Yeah. So as I mentioned, we ran those vessels with Marine Patrol. They came back to the corporation, the same corporation that's advertising on Groupon. At this point in time, the advertisements are still live and active as of the final reinspection date. And at this point in time, the city is requesting an adjudication as well as a one-time fine to stay in uniform with the previous case that was ongoing.
If we can we allow the interpreter? Please feel free to, remind us to allow you to interpret. You're muted, sir.
Yeah, sorry. As an interpreter, I didn't interrupt since it seems that Mr. Ernesto is understanding everything. So let me make sure that he's understanding. Señor Ernesto, ¿usted está entendiendo todo lo que se le está diciendo?
No. Todo no. Entiendo, puedo entender algo, pero habla muy rápido.
All right. So go ahead and interpret everything.
Of course. Muy bien, señor. Entonces, bueno, lo que se le está diciendo, lo que se está diciendo en este momento es que lo que se está mostrando en pantalla precisamente es un anuncio respecto a los fletes que se están haciendo que el punto de partida de estos fletes, de donde se ubican estos barcos o los buques, es en la dirección 2055 Park Creek Drive, y donde también se menciona que estos barcos o el buque o los buques están registrados a nombre de la compañía TLM Marine LLC.
Sí.
All right. Okay, we're going to move on. Code officer, tell me any more information. By the way, how long has this been going on?
So the case was originally started on June 6th of 2022. So it's been quite some time now. And I actually just looked up TLM Marine LLC on Sunbiz, and the registered agent is a Maria Jose Moreno, which would not be the property owner who was here at the time.
Bien, entonces se pregunta al señor oficial de cumplimiento que si desde esta situación, desde hace qué tanto tiempo está ocurriendo, donde se tiene que este caso se abrió desde junio 6 de 2022. Ahorita se acaba de revisar la base de datos con respecto a quién es el dueño de TLM Marine, quien se tiene aquí como María José Moreno, donde claramente no es la persona que se tiene aquí como que está presente como dueño de la propiedad.
Sí, yo podría explicarle un poco mejor si quieren para que comprendamos la situación.
So I could explain myself a little bit better so we can understand the situation.
Okay, but I'm going to wait until Mr. Perez finishes his presentation.
Está bien,
this point,
pero
it's
vamos a
fine.
esperar hasta que el señor Pérez finalice su presentación.
At this point in time, the city doesn't have any further evidence to present. We're fine and have no objections with Mr. Ernesto.
Okay, what
speaking
do you have any? Do you have any videos of alleged purchasers or people using the services provided by Mr. Pasiola?
No, this violation is specific for the advertisements, and therefore the case was opened because of the advertisements.
Okay, and the advertisement mentions the property address?
That is correct, yes.
What do they charge for your regular voyage around Biscayne Bay and a few hours at Hullover? What is their charge?
It says to contact them for rates, but it says from $1,300. So I'm guessing the base rate would be $1,300, and that has contact them for the details.
Okay, but does it say where the passengers will be taken?
It does not. It just says that the departure point is 2055 Arch Creek Drive.
Okay, now, Mr. Pasiola, I'm going to give you an opportunity to present your case. And feel free, if you want to cross-examine the code officer, you have the right to. Mr. Interpreter.
Entonces, muy bien. Entonces, ahorita le preguntó al señor Pérez si tenía más evidencia que presentar, a lo que el señor Pérez responde que no. Se pregunta si hay videos que aleguen que estos servicios son proveídos por el señor Pasiola, donde dice que no se encuentran videos respecto a los servicios proveídos. Aquí la situación, este caso se abrió debido al anuncio, donde se pregunta si el anuncio menciona la dirección. Donde está, el anuncio dice que sí lo menciona. Se pregunta que sí, cuánto es lo que se cobra por un puesto de unas cuantas horas, donde lo que el señor Pérez responde es que al anuncio menciona que se tiene que poner en contacto para revisar los precios, pero se tiene como base que son por lo menos $1,300 y que se contacte que es a partir de base $1,300 y que se contacte para más detalles. Ahora, si se menciona cuál es el punto de partida donde los pasajeros estarían siendo cargados. No se menciona eso, pero menciona que el punto de partida es en la dirección 2500 Parker Drive. Ahora se le está dando a usted, señor Ernesto, la oportunidad para presentar su información, así como también usted tiene el derecho de hacer una examinación cruzada con el señor oficial Pérez.
Correcto. En junio del año pasado yo recibo una carta del oficial Pérez y intercambiamos unos mails debido a eso, ya que la carta mencionaba a una empresa, que la tengo aquí, la primera carta, Yacht Church in Miami, y entonces yo ingreso al sitio web porque no soy yo y veo que había un C-Ray parecido al mío, que es de aquí de la zona. Entonces yo le envié un mail a la agente Pérez para comentarle que ese barco no realizaba charter, quizás habían confundido con el otro y que yo no tengo nada que ver con ese sitio web que ellos mencionan en la carta. Luego, entonces,
un segundo, señor Pastora. Ahorita continuamos. All right. So this is interpreter. I just let him know that I will interpret this, and we'll continue after that. So June. So this happened in June last year, where I received a letter from Officer Perez. After receiving that letter, we had several communications through mail, and that in the mail it is stating the name of a company, something as George Church in Miami, which this is which it seems that this company is using a vessel that is similar to mine, but it is not actually myself. I look at in the website of this. I look at the information of this company, which it seems that it's a charter company. But well, my vessel doesn't do any charters. I do not have anything to do with it, with its company.
What vessel is the one that is under that website address?
Entonces, ¿cuál es el buque o el barco que está enlistado en ese sitio web?
No, ahí quisiera continuar. Entonces, cuando yo le digo a la gente Pérez que esa empresa de la carta no soy yo, él me envía un advertising que habíamos realizado, pero que era una intención de realizar charters, que no, al final nunca lo hicimos y ni nos acordábamos que estaba el sitio web ese. Entonces, cuando él me comenta, nosotros damos de baja automáticamente. Eso fue a los 3 días de haber hablado con el agente Pérez, se dio de baja el advertising ese. Y además no era que decía que la gente se recogía en la casa, sino que el barco, la localización del barco era aquí, que era lo usual. Tú luego le puedes indicar a la gente dónde sube, dónde baja y demás. Pero era una intención, incluso yo se lo comenté, que íbamos a incursionar en ese rubro y como él me dijo que no era posible, que debíamos dar de baja el sitio ese, el advertising en Groupon, lo dimos de baja inmediatamente. Lo que yo hago referencia es que la página web esa en la carta yachtchartsinmiami.com no somos nosotros y yo no puedo dar de baja eso porque no es mío.
Whose is it?
Sorry, this is trouble. I will interpret that. So continuing with what I was talking about. So. Okay, so when I was told that the company in that letter about that company, and I replied that the company that is mentioned in the letter it wasn't me. He sent me the advertisement, and so I saw the advertisement and it was actually an advertisement that we did that because we did have the intention to go into that business, but since Mr. Perez told us about it, we took the advertisement down 3 days after talking with him. With that, in that advertisement, it is stated that the vessel was located in that address, but it didn't mention that the departure point it was that address. We had the intention of like with the clients. They will let us know, or we will let them know where will be the departure point. But since Mr. Perez told us that it wasn't possible, we took the advertisement down. Now the other website is the yachtchartsinmiami.com, but that one I'm not able to take that advertisement down since I'm not the one who posted.
Who posted it?
¿Y quién lo publicó?
No tengo idea. No, yo no conozco esos barcos que estaban allí publicados, ni el sitio web, ni tenía idea de la existencia de eso.
Has there been more than one vessel operating out of your property at 2055 Arch Creek Drive?
So just to interpret what he answered to the previous question, he said, I do not have an idea. I do not know any of the vessels or the existence of this. Ahora, señor, la pregunta es, ¿hay más de una embarcación operando en la dirección 2055 Arch Creek Drive?
No, operando no hay ninguno. Aquí no hacemos charter y esos barcos de la foto que vimos recién eran míos, que los vendí el año pasado. Fue enseguida, yo le comenté al oficial Pérez que estaban en el proceso de venta, inclusive en los mails. Y Y desde el año pasado, de julio, que ya no los tengo más.
No, there is nothing in operation since we do not do charter. The vessel that it was shown in the photographs, I sold them last year. Actually, in the mails in the communications through mail that I had with Mr. Perez, I mentioned that I was in a process of selling. And so by July it was sold, and I do not have them anymore with me.
Sir, are you telling us that you have never done a charter out of 2055 Arch Creek Drive?
Señor, entonces usted nos está diciendo que nunca se ha salido una embarcación de la dirección 2055 Arch Creek Drive.
Embarcación sí, no charters.
For vacations, yes, but not charters.
Tell me about those vacation trips.
Dígame respecto a esos
voyages.
Entonces, señor, dígame respecto a estos viajes de vacaciones.
No, utilizar el barco de placer, digamos, ya sea con amigos, familia, lo normal.
Well, I use it like in a recreative way with friends or family, the normal.
Do you charge them?
¿Y usted les cobró?
No.
No.
Who paid for the gas?
¿Quién pagó por la gasolina?
Yo siempre.
I did always.
Okay.
If I may.
Yeah, I'll let you weigh in, Jose, but let me just ask one final question. When you place that advertisement for charters and including your address, are you telling me that just shortly after that advertisement, you heard from the code officer and you pulled the ad and you never engaged in any charter from the property? Is that your testimony?
Entonces, señor, una pregunta final. Entonces, me dice que usted nunca ha hecho embarcaciones donde esto... perdóneme.
Charters.
Sí, bien, nunca he hecho cargas de embarcaciones donde estas this is interpreted. I actually I was interpreting the previous question. Let me interpret the actual question, Mr. Smith. Entonces, señor, en el anuncio en el que usted publicó, dice que donde está incluida la dirección. Me está diciendo que después de haber puesto este anuncio para estas embarcaciones, usted fue contactado tiempo después por el señor Pérez y después de haber escuchado al oficial, usted quitó el anuncio. ¿Ese es su testimonio?
Sí, correcto. Inclusive yo le comenté al oficial Pérez que ese anuncio lo habíamos puesto hacía una semana o dos con esa intención y bueno, y se dio de baja al momento que él nos comunicó y nos brindó el sitio, porque inclusive no recordábamos dónde estaba realizado la publicación. Entonces fue él el que me brindó el link para yo poder darlo de baja. ¿Habrá sido todo la misma semana o 2 semanas?
So yeah, that's correct. So I posted this advertisement with this intention. So after 1 or 2 weeks after that is when I got contact by Mr. Perez, and so when I was contacted, I took the advertisement down, since I actually didn't remember where like the link or where this advertisement was posted, and actually it was Mr. Perez the one who provided me with that information, and so I took it down afterwards. So this happened in a period of 1 or 2 weeks.
Okay, I don't want to be caught up in semantics. I want to be specific. You're telling me that you or no member of your family ever charged members of the public money to get on your boat for a tour, whether Haulover or Biscayne Bay, or that you never brought anybody on board and charged for that service?
Bueno, entonces, para evitar irnos entre los aspectos semánticos, quisiera ser más específico. Entonces, ni usted ni ningún otro miembro de su familia nunca le ha cobrado a algún miembro del público, alguna persona del público, dinero para subirse a su bote. O sea, nunca ha cobrado, ya sea por dar un tour en Haulover o en Biscayne Bay. A nadie se le ha cobrado por abordar.
No, por abordar aquí en la casa, no.
No, like to do a charter here at home now.
Okay, so now I'm going to turn to staff. Mr. Perez, you've heard the property owner very clearly under oath deny that he's ever done a charter out of the house, even though he originally intended to do that. He immediately got a call from you and was told that he couldn't do it, and he said he followed your direction and never did a charter. So what evidence can you provide me with to rebut those statements?
Okay, so this violation in question is actually not for the charter activity itself, but rather for the advertisements. So at this point in time, the city respects that he has not chartered, and we're not contesting that he may or may not have chartered, but rather we're advising that the advertisement is active on Groupon.com, right? So there have been 2 advertisements, one at Yacht Charters in Miami.com, which was removed. So that sufficed that aspect. But on Groupon.com, there's an active advertisement that's up to this date. I just got on the website and I double checked. It's still active. That needs to be removed. Because as it still mentions, the departure port is that property. So if that advertisement is removed, then this would satisfy the case. We'd be able to close out the case, which is not a problem. So at this point in time, we're just seeking maybe an adjudication and allow them some time to remove that advertisement from Groupon because it's still active.
Okay. So why don't you let's have the interpreter explain or translate what the court officer just stated.
Muy bien, entonces se le dice al oficial que pues claramente, o sea, escuchándolo usted diciendo, explicando claramente bajo juramento que a pesar de que tuvo la intención de hacer estos cargos de embarcaciones, usted nunca hizo uno. Al haber escuchado al señor Pérez, al haber escuchado las indicaciones del señor Pérez. Ahora se le pregunta si hay algún tipo de evidencia que refute el hecho de que usted comente que nunca ha hecho ninguna carga. Entonces, lo que el oficial Pérez responde es que esto, más que lo que respecta de esto, no se trata con respecto a estas embarcaciones, se trata más respecto al anuncio al anuncio del servicio de las embarcaciones, donde el señor Pérez comenta que había 2 anuncios donde el anuncio en el sitio web de Yacht Charters, sí fue removido, más el anuncio que está en otro sitio web llamado groupon.com aún sigue activo. A este momento el oficial ha revisado si el anuncio sigue activo en este sitio web, a lo que sí sigue activo en el groupon.com. En Yard Charters no lo está. Entonces, mientras que entonces explica el oficial Pérez que mientras se baje el anuncio del sitio web de groupon.com, se estaría satisfaciendo el caso.
Ajá.
Ahora,
tendría que chequear porque yo, como les comenté, el año pasado cuando me contacté con el oficial Pérez lo dimos de baja. Quizá hay algún error o algo, pero lo puedo volver a chequear. Incluso tengo los mails donde como lo dimos de baja, como no era la primera vez que hacíamos ese anuncio, no tenía idea cómo funciona ese sitio y se había dado de baja parcialmente, entonces vuelvo a chequear con el oficial Pérez y ahí lo dimos de baja bien, pero pensé que estaba dado de baja. Les pido disculpas y voy a chequear y si podrían enviarme la dirección del anuncio, quizá es otro anuncio, porque inclusive donde nosotros lo publicamos no es Groupon. Era otro sitio web que no sé por qué aparece allí como oferta de cupones o algo así, pero era otro sitio web que ahora no recuerdo.
Okay, so well, I will need to check on that. It might be an error. It might be an error. Since that was the first time that I did the advertisement. I didn't know how to use the website in a proper manner. So it might be an error, and I'm sorry. I will check that. If you can go ahead and provide me the address, I will take the website address. I will take a look in that. But as far as I know, we didn't post anything in Groupon. I know that we posted in a different website, but I wouldn't know why is it in Groupon since.
Well, Mr. Perez is saying that he's looking at the advertisement on Groupon.com right now.
Sí, bueno, sí, el señor Pérez está comentando que en este preciso momento él está en Groupon.com y ahí es donde se encuentra el anuncio actualmente.
Ok, lo podría compartir en vivo, así ya lo miro, porque no.
No, the officer will contact you.
Okay, no problem. Great.
Okay, Madam City Attorney, anything in the code that prohibits advertising boat charters, similar to advertising short-term rentals?
I would actually ask the code officer, where in the code section does it say that? Because I couldn't find it myself. But it seems like he was citing the property owner for charting the boats and not for the advertising. But I would ask for some clarification on that and what his intent was with the code violation.
Mr. Perez.
So the violation is actually for the actual advertisements itself, as it relates to the violation under Chapter 29-5-601, subsection E, subsection E5, renting of docks, dock space, moorings, or the rental of boats, or any thereon portion for any purpose whatsoever shall be specifically prohibited in residential districts. That's the subsection we're using.
Okay. Okay. Mr. Interpreter, just explain what the officer said regarding the rentals of charters.
Bueno, ahorita se pregunta si hay algún estatuto del código donde hay alguna prohibición al anunciamiento de esos reglamentos o rentas cortas, a lo que el oficial de código comenta que están utilizando, que se está citando lo que es, que es la violación está basada bajo el capítulo 29-5-6 subsección E, donde en esta subsección lo que no está es hacer ese tipo de acciones en distritos residenciales. Entonces es esa subsección que es la que están tomando como base para esto.
All right. I'm gonna find, based on the evidence presented, that the city has not met its burden of proof with respect to actual boat charters engaging in illegal, prohibited charters from the subject property. However, I do find in favor of the city with respect to the improper, illegal advertising of the property as a place from which charters would be allowed. And I don't know what the specific code provision provides as far as a penalty is concerned, but I know that I have the authority to impose a fine for code violations under 163 of the Florida statutes. So I am going to fine the property owner based on the evidence presented that there was improper advertising, and I'm going to fine. I'm going to enter a fine in the amount of $500. And of course, I am going to order, to the extent that I can, that any future charters from that property are illegal and will be subject to the maximum fine allowed by the code in these matters. So I caution this particular property owner and any others that I don't take these violations lightly. I know it goes on. The Miami Herald has done a few articles on this. Many of the people that do steer these vessels, most are not captain licensed to do these kind of charters. So it is a safety hazard, and it's been identified as the cause of some accidents recently in South Florida. So that's my ruling, a $500 fine based on the advertising.
And that would be a one-time fine?
One-time fine, yes.
Muy bien, entonces voy a estar dando mi decisión, donde, bueno, basándonos en lo que no se pudo proveer evidencia con lo que respecta el que se hagan embarcaciones de la dirección mencionada, debido a que esta acción debido a que no se mostraron las evidencias de que hubo embarcaciones saliendo de esta dirección, lo que respecta a eso, no se estaría encontrando en favor de la ciudad. Lo que sí se estaría encontrando en favor de la ciudad es el anuncio no apropiado o ilegal respecto a que el lugar donde estarían saliendo las embarcaciones no son permitidos. Ahora, no tengo muy segura la penalidad o la multa que esto requiere, que esta situación requiere, pero sé que que sí puedo imponer una multa basada en la violación del código de $173, basados en el código 163 del estatus de Florida. Entonces se estaría dando una multa por el anuncio inapropiado de una multa de una sola vez de $500. Así como también estaría poniendo una orden que en el futuro ningún tipo de cargamento puede salir de esta propiedad, de esta propiedad, ya que esto es un acto ilegal. En dado caso que esto ocurriese, se estaría imponiendo la multa máxima permitida por el código respecto a esto. no tomó estas violaciones a la ligera. El Miami Herald ya ha puesto artículos al respecto, donde muchas de estas embarcaciones no cuentan ni con un capitán que tenga la licencia apropiada para ello, ocasionando dando lugar a posibles accidentes.
Okay, that's it. Next case. Let's move on.
Bien, entonces estaré pasando al siguiente caso.
Item number 20 and 21, Invest and Conquer LLC, case number CEBPR 20220056A.
All right, I just want to announce after we hear 20 and 21, we're going to take a 10-minute break. So if you're not 20 or 21 and you want to go out for a quick lunch, now is a good time.
Item number 21, case number CEFAW 20220063, and the officer is Gennaro Murillo.
What do we have here on behalf of this case? Oh, it's Enoch Bond here.
Yes.
You read number 20 also?
Enoch Bond here. Okay.
We're doing 20 and 21, correct?
That is correct. 2021.
Okay, let's do 20.
Enoch, are you there?
Would he need an interpreter?
Yes, I'm here.
Can you enable your video, please?
I'm trying to get my daughter to help me. I don't know. Okay. Yes, I'm here.
Please raise your right hand.
I'm Enoch Bonner.
Please raise your right hand, sir. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
Yes.
Sir, please state your full name, home address, and your relationship to the property.
Enoch Bonner. The home address is 13900 Northeast 11th Avenue in North Miami, Florida, 33161. That's my mother's house. We have dementia. I took over the house and paid it off and put it under my company's name.
All right, and your company is the Invest and Conquer International LLC, correct?
That's correct.
And you are the manager of that LLC?
That's correct.
Have you been made aware of the alleged violations on the property relating to the need for a building permit to build a new fence?
No, my brother gave me the paper. I went to the city to try to see the officer, but at the time when I got there, they told me the officer was gone. So
okay, so there's the fence. It's a very pretty fence. Unfortunately, it was done without a permit.
Brother did that.
Okay. Do you contest the violation or?
Yes, that's a bit. My brother did that. Yes.
No, what I'm asking you is that you agree that that fence was built without a permit.
Yes.
Okay. And have you taken any steps to acquire a building permit from the city?
I didn't know what they were referring to because in the paper it mentioned chain link fence. I thought it was the fence that's in the front.
That's the next case. That's the next case. This case is the white fence that was just shown on the photograph. Show it again, please.
I wasn't aware of.
Mr. Murillo, can you show the fence again, please? You see that fence?
Yes.
That was done without a permit. Have you filed any paperwork with the city to legalize that fence?
No.
Okay, well, I'm going to give you how much time do you need to do that?
Can I have 90 days?
No, I'm not going to give you 90 days. That's too long, and it doesn't take that long. I'm gonna give you to June 15th. How's that?
Can we have June 30th? There was a around the property.
Listen, all you need to do is get someone licensed, contractor or otherwise. Whoever put up that fence, well, I don't know who it was, but whoever put up that fence needed to come to the city to get a building permit. And all it is, you file the paperwork, the building official sends an inspector, and if everything's been done according to code, you get the permit. It's not a big deal. Okay? So, Officer Murillo, anything else on case 20?
No, sir.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photograph and the evidence presented depicting that the cited violation still exists, proper notice has been given, property owner is present, I find in favor of the city and enter an adjudication and set an abatement date or compliance date of June 15, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So, sir, get moving on it. Let's hear number 21 now.
All right, thank you. Oh, there's another.
Can I proceed, Your Honor?
Yes. 21.
Yes, on June 8, 2022, a violation was open to repair, replace, or remove the damaged chain link fence. On reinspection on June 24, 2022, there was no compliance. A notice to appear was posted on March 3rd, 2023. It was also made on March 9, 2023, and some final reinspection, the fence remains.
Okay,
damaged.
so it's a chain link fence. I'm surprised the city allows chain link fence around the perimeter of a property. Usually it's not, but is the issue here is that the fence is damaged.
We've owned this property since 1993, Your Honor. So I guess that fence was something that was put up way back around 1993.
Well, does it look good to you?
A car hit the fence. No, of course not.
Well, then did you collect insurance from that car?
No.
Well, that fence needs to be fixed or replaced. It's an eyesore. It's right at the front of the property, and it's not consistent with the code as the officer stated. I think you cited 29-5-1209D. So he determined that it's in violation and it's got to be fixed. How much time do you need? I'll give you more time on this fence because I think this will take a little bit longer.
3 months is good enough.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice has been given, the property owner is present, I find for the city, enter an adjudication and set a compliance date of July 20th. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Sir, if you run into some kind of a problem, unanticipated issues, you can't find contractor or cities that is busy, you're not getting the paperwork done and whatever. I mean, I'm lenient. You can, in that regard. I mean, you gracefully acknowledge the problem. You agreed that it needs to be fixed. So even though I'm giving you 90 days, if come the 90 days, you've gotten your permit, you've gotten your contractor, but you haven't dotted all the I's and crossed all the T's. I'll give you a little extra time, but let's try to do it by July 20th.
All right. Thank you, John.
Okay, thank you. At this point, I'll recess for 10 minutes, if you don't mind. Bathroom break, whatever.
No problem.
Recording stopped.
All right, you ready, Magistrate? You're muted, but I'm going to go ahead and resume the recording.
Recording in progress.
Can you hear me?
Yes.
All right, let's go on.
Clerk, are you there? All right, I'm going to go ahead and call let's see who's here in the queue. Sorry. All right, I'm going to go ahead and call number 24, JC 125th Street, LLC, MHVIO 2022-00459, property address 447 Northeast 125th Street. Gennaro Murillo is the code officer, and I have a Kevin Kohler here on behalf of the property. Mr. Kohler, if you would enable your audio and video, please.
Yep, hello.
Yes.
All right, let's swear him in.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
I suggest that if you're driving, that you go off the side of the road and stop for a minute. Don't want you to get into an accident.
Yes, sir. Pulling on the shoulder right now.
Okay, thank you. All right. Mr. Kohler, what is your relationship to the property?
I'm the property manager.
Okay.
I have a power of attorney by JC 125th Street that's filed with the city with the permit application regarding this case.
Is there a Subiana Kohler? Is that your wife?
She is.
Okay. So you have been charged with having built a dumpster enclosure. I understand that that was done without a permit. The city is requiring you to obtain an after-the-fact building permit. You understand that?
I do understand, sir.
Okay. How much time do you need to comply?
The permit was submitted last week. It took about 8 months for us to find a contractor willing to do a job with a little scope such as this. But we did have one and submitted everything. The permit receipt or the application, sorry, the permit number is BFE 002023000058.
Has there been a final inspection?
No, it is still in review, and we are prepared and willing to get the permit and the work done in final inspection and everything within a matter of days after approval.
Yeah, Officer Murillo, you've been sworn before. You saw that. Was that your picture, or?
Yes.
Okay, so is that the work that was done?
Yes, sir. Yes, I just see he applied for a permit on March 30.
March 30, he applied for a permit?
Yes.
Okay. How long will it take him to get his plans reviewed and approved?
Well, that will be up to the building department. No.
I'm not sure, Magistrate, but we would just ask that, we're happy to give him the time he needs, but we just have to see you into the adjudication.
Yeah, I was, you said that the city's asking for an adjudication?
Yes, sir.
Okay. So, sir, I'm going to give you whatever time is necessary for the city, for the building department to go through it, but I do want to put a deadline on this. So what I'm going to do is I am going to adjudicate based on the evidence presented. I'm going to adjudicate in favor of the city because work was done without a permit. I am going to give you until June 15th to abate the violation, meaning you have a couple months to get your permit. And in the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. But there is no fine. There will be a fine if you don't get this done by June 15th. Obviously, if the city drops the ball and there's a problem, bureaucratic issues come up, I'll consider extending it. But as of right now, June 15th is the deadline by which you must get this approved by the city and get an after-the-fact permit.
Okay, thank you. We appreciate it. This was done by a previous management company, and we're just cleaning it up. So thank you, sir.
All right. Good luck and safe driving. Next case.
Thank you very much.
Item number 32, Perry Lanaway, case number CEBPR 2022000564. Officer Jose Perez.
Who's present?
Hey, who do we have here?
Let's see.
If you're here on behalf of this property, please click the raise hand feature.
Perry?
Who?
Perry Lanaway.
I'm on earlier.
Is there anyone here on behalf of this property?
I'm not seeing them in the attendee queue anymore.
Okay, so let's go with we've got 5 people here. Let's call Ely Bardwell.
Case number?
Eli, what property are you here on behalf of?
Ely and C.
What property are you here on behalf of?
Ely and C.
Can you give me an address, please?
13226 West Dixie Highway.
That's item number 14.
Do you need the case number?
We have that.
Item number 14, EBNC Investments LLC, case number CEFLR 202200387. Any officers, Christopher Colton.
All right, sir, if you can enable your audio and video, please.
All right. Is the property owner present?
Yes, I am, sir.
Lee Bardwell?
Yes, sir.
All right. You need to be sworn.
Yes, sir.
Please raise your right hand.
Yes, sir. Yes.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
Yes.
Please state your full name, address, and your relationship with the property.
Ely Bardwell, owner, address P.O. Box 610365, North Miami, Florida, 33261.
And the property that you own is located at 13226 West Dixie Highway?
Correct.
Is that a commercial property?
Yes, sir. Yes, Officer Magistrate.
And you're being charged with not having a business tax receipt for the New Style Barbershop. You understand that?
Yes.
How long do you need to go out and get a business tax receipt? How much time do you need?
I am working with the tenant to do this. I'm not sure if it's just a simple renewal. They have been there from before and previously. They haven't physically truly operated in, I want to say, maybe 2 months. And I've been working with them to see if they want an exit strategy from the lease because they are in arrears. But I will take 30 days, 60 days, whatever. You will provide us with the opportunity to go back to Nadej and to be able to finalize the renewal of the permit.
Well, if they don't renew the permit, I'm going to fine them. Or alternatively, if they shut down, go out of business, then they don't need a permit. So you'll have to talk to your tenant to see what their plans are. If the plan is to shut the business down, don't need a permit for that. But if they're going to operate even for one day,
right,
they're going to need a permit.
Right. Currently, I don't believe that they have really been operating as a barbershop or anything. Currently, I don't even believe their water is currently even turned on for it, and so they are like I want to say maybe 2 months, 3 months in arrears, and I've been working with them to, to be able to say to move forward. They keep telling me, no, we're going to try to make it. If you provide me the time of the abatement, I will go back.
I'll give you a little bit of time.
Okay.
After that time, if they're still operating, even if they're just cutting one head, one hair a day,
right,
they're going to have to pay. They're going to have to pay fine. So based on the unrebutted testimony of the city's code compliance officer, by the way, does the code officer want to say anything?
We just seeking the adjudication, Your Honor. Everything else is fine.
All right. Are they cutting hairs or?
No. Currently, no. Oh, sorry, officer.
Now, when I went by there, I didn't see anybody to talk to at the time. When I went over there, I posted a notice and everything. So, and I mailed them out. I didn't see anybody to talk to.
Yeah.
One day, a while ago, but in recent, no.
Yeah.
Well, this is what I'm going to say. That based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists, proper notice has been given, the agent for the property owner appeared. I find in favor of the city, enter an adjudication and set a compliance date of May 18th, or is it May 10th? I forget.
May 18th.
May 18th. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. Thank you.
Thank you, Magistrate Smith. So is there anything that I need to do, or once it hits the file, it then gets completed, or do I need to to demonstrate it to the court?
Speak to the officer, and if it looks like it's not going to work out, just close the business, get a new tenant, and then we'll talk about what the new tenant needs to do. But if they're going to keep operating past May 18th and they don't have a business license, they're going to have to pay a fine, or in this case, you as the owner will have to pay a daily fine of $250. So you have a lot of options here, and we don't know what's going to happen. So just in case, prior to May 18th, let the code officer know what's going on.
Thank you very much, Magistrate. We'll finalize for you before May 18th.
We'll call item number 51, the Vanadu Prop LLC, case number SDNOV 2022007445, and the officers Jonathan Willow and Richard Cristiano is here on behalf of the case.
Richard, are you there? Richard, are you there? All right, we would kindly just ask that if your case is called, you're available. Otherwise, we're going to have to move on to the next case. Last call, Richard Crisoninho.
You're muted.
Richard, are you there? All right, let's call the next case. Table it for a moment, I guess. Do we know who the other people are?
Yeah, they're now responding to the chat.
Okay.
I'll go back to item number 32. Tracy Hancock will be the one hearing it. Perry Lanaway, case number CEBPR 2022-00564, and the officer is Jose Perez. Item number 32. Please raise your right hand, ma'am. You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
Yes, I do.
Please state your full name, address, and your relationship to the property.
Tracy Hancock. The address is 1970 Northeast 124th Street, North Miami. And I'm one of the owners.
Okay, and who's Perry Lanaway? Is that the other owner? Sorry?
My partner.
Okay. Do you understand the charges against the property that the city filed?
As I understand it, we have an office shed that's been constructed on the property, and we are going for a permit after the fact.
Okay. How much time do you need for the to get a permit?
We actually have the permit number. We were trying to contact somebody prior to this meeting to advise of that, but we didn't get a response back. So that's why I've attended it.
All right. So that the record is clear, I want the code officer, Mr. Perez, to briefly tell me what this case is all about.
Officer, I'm sorry. Jose Perez, co-compliance manager for the City of North Miami. We're hearing the case in regards to the property at 1970 Northeast 124th Street. This case as relates to work that was done without permits, specifically a shed that was built in the rear of the property. The violation originally was cited back in June 6th of 2022. As of my final reinspection, unfortunately, the permits had not been obtained. The final reinspection was done on March 16, 2023. Therefore, the case was scheduled for the hearing. Originally, the property was given until July 5th, 2022 to obtain the permit. No application file had been made, which is why the property was failed for the hearing. And as I previously mentioned, the final reinspection, which was done on March 16, 2023, no permits had been obtained. At this point in time, I am checking the system and
check and see if a permit was issued.
I can give the permit number if that helps.
One second, ma'am. 1 second. I am seeing that there was a canceled permit that was applied for on April 1st, 2023. So they applied for a permit on April 1st, 2023 through web, right, through the internet. However, that was canceled as of April 3rd, 2023. So at this point in time, they are not in compliance with obtaining a permit.
What happened, Ms. Hancock? The permit was canceled by the city or by you?
I have no idea. That's the first I've heard of it. I have the permit number here in front of me, and I've received no notification of a cancellation. I'm sorry. So completely news to me.
Why don't we make sure that we're talking about the right permit? Can you tell the code officer what the permit number is?
Okay. The permit number that I have is B for Bob, SH00-2023-00007.
Okay, yeah, that one comes up. There was two here. I guess they canceled the second one because of this one. This one, again, was applied for on April 1st and is pending. So at this point in time, the city is not objecting to granting them more time. We will request an adjudication, though.
Okay. Ms. Hancock, even though you, as of today, you're not yet in compliance and technically subject to a fine, I'm not going to fine you. I'm going to give you time, plenty of time, within which to get your permit. However, if you drag your feet and not follow through and get your permit reasonably soon, there will be a fine associated with that non-compliance. So based on the unrebutted testimony of the property owner and the code compliance officer, and the evidence presented depicting that as of today, the violation still exists, proper notice has been given, I find in favor of the city and enter an adjudication and set an abatement date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So, ma'am, you have until May 18th. That should be plenty of time.
That should be fine. Thank you.
Okay, thank you.
Yes. Great, thanks.
Item number 15 through 18, Eloran Properties Northeast 125th, Miami. Case number for item number 15 is CEFOB 2022000357. Item number 16, case number CEZCU 2022000648. Item number 17, case number MHVIO 2022000365. And item number 18, case number is MHVIO 2022000368. And the officer is Gennaro Murillo. And we have Leor Fennell.
Leor, are you there?
Hi, guys.
Sir, please raise your right hand.
Good afternoon.
Sir, please raise your right hand.
We have also Sylvia on the line. If you want to join her as well.
Well, we're gonna have to swear you in first, and then we'll do her.
That's fine. Here.
Go ahead, Madam Clerk.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
Good afternoon, office.
Anybody else going to testify?
Sylvia is here on the line.
Sylvia Asulin?
Yes.
Yeah. Hi.
Ma'am, please raise your right hand and be sworn.
You solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Okay, I have, let's see, 1, 2, 3, 4 cases on this property. We're going to take them one at a time. They're all different. Let's start with number 15, which is the business tax receipt. I want to hear from the city.
Good afternoon. Good afternoon. Sorry. Officer Murillo for the City of Miami Code Compliance. On May 18, while conducting annual housing inspection, I opened a violation for not having a business tax receipt for the City of North Miami. I had a reinspection on June 8. There was no compliance. A notice to appear was posted on March 3rd, 2023. It was also made on March 9. Some final reinspection on March 16, 2023. There was no licensee on file.
What kind of business is it?
This is a motel family.
It's for the whole property or just one business?
Yes, for the whole property.
Okay, so it's a multifamily building.
Yes, sir.
Okay, let me hear from the property owner, Mr. Ganel or Sylvia Asulin. What's the problem? What's the problem with the business tax receipt?
No, we have it. It's posted by the mailbox or by the meter room. So when they contact us, we give the access for the meter room. But we have it by the mailbox, which is a shaded area.
You have a copy of it with you by any chance? Maybe you took a picture?
Okay. Let me try to find out in the meantime. Yeah.
We pay annually. We always pay it. We always post it.
Yeah.
There is no issue with any of our property.
Well, does the city have any record of a business tax receipt being?
Should have. The city should have.
Yeah, well, let's ask the city first.
Your Honor, no. When I went to the property, they only had the county. They have some county permits. They have no licensee from the city of North Miami.
Well, maybe that's the problem. Maybe you believe that the city doesn't require a business tax receipt, that only the county does, but the city does require a BTR.
No, we have it. I know
We have
for sure.
everything.
Okay. Let me try to find that and I'll share this with you now.
Well, if you can find it within the next 5 minutes.
Yeah.
And you can send it to the city at whatever email Officer Murillo has. We can resolve it right there and then.
What number is this?
This is number 15, case 15.
Do we have a licensing screenshot here?
Excuse me, Kristen?
Do we have a licensing screenshot, or are we able to? Do they have a CU?
No, they don't. They don't have a CU
that's the
or
next
a
case.
BTR.
Okay.
I'm looking at licensee right now, and this business, or rather this property owner, does not have a CU or BTR with the city of North Miami. The last one that had one at that address is under 1595 Northeast 125th Street LLC, and that expired back in 2015.
What?
Well, what I'm understanding is that there was a prior business with a different name.
Right.
Property was owned by a different company. They did have a BTR and a CU, certificate of use, but that your corporation, is there a corporation or an LLC?
LLC.
LLC.
All right, so your LLC does not have a business tax receipt unless you can show us. We're going to do an adjudication and give you time to get one.
Okay.
All right. I mean, if you have it, no harm, no foul. If you don't have it, you have to get one. So on the business tax receipt case, which is case number 15, based on the testimony of the city's code compliance officer, the evidence presented, testimony heard from Mr. Perez as well as Mr. Murillo, I find in favor of the city. Enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So let's move on to number 16, which probably will end up with the same result, because if you don't have a BTR, you're not going to be able to get a certificate of use. I'm going to ask the property owner if they can show me evidence that they have a certificate of use from the city of North Miami.
Okay. Go ahead, Gennaro.
There you go.
Yeah, go ahead. Go ahead.
Yeah.
Yes, Officer Murillo for the City of North Miami Code Compliance. On May 18, while conducting an national housing inspection, I opened a violation to the property for not having or obtaining a certificate of use from the City of North Miami. There was a re-inspection on June 8, 2022. There was no compliance. Notice to appear was posted on March 3rd, 2023. It was also mailed on March 9, 2023. There was a final inspection on March 16, 2023. There was no license on file.
All right, and the certificate of use, just for the property owner's edification, is a certificate that is issued by the Planning and Zoning Department, suggesting that the property is zoned for the business that they operate, correct?
Okay.
So Murillo?
Yes, sir.
Okay, am I correct?
Yes, sir.
All right. Anyway, what's the owner's response? Do you have it or you don't have it?
We were under the impression that we have it. If we don't, we will obtain it immediately.
Okay, we'll give you time to obtain the certificate of use. Now, the certificate of use is a different animal than a business tax receipt. Business tax receipt, you just pay a tax and you're done. Here, it may require a zoning inspection. So I'm going to give you a little bit more time on the certificate of use because dealing with planning and zoning is a little bit more difficult. So as to this particular violation, number 16, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists, proper notice has been given. I find in favor of the city, enter adjudication and set a compliance date of June 15th. In the event of non-compliance, there shall be a daily fine of $250 until the violation is abated. So you got a little bit of time, but I wouldn't be wasting it. I'd be getting on it right away.
We will address it right away.
Okay, thank you for your...
Submit it online or is it physically going to the city?
I'm sorry?
Do we submit the application online or this is something that needs to be physically done in the city?
I'll defer to staff to explain how it's done.
Yes, sir. You would need to physically come into the city.
Okay, will do.
Okay. Now, the business tax receipt is with the finance department. Is that correct, Crystal?
That's correct. So you're both licenses are both offices are housed in one building. So just come to the city, go to our community planning and development office, and let them know what you're looking to do, and they should be able to assist.
Perfect.
Okay, great. Have a great afternoon. Next case is number 17, same property?
Yeah, 17 and 19.
Same property. This is sliding door screens. Why don't you present? Oh, we lost them.
Yeah, I thought they were done. Sorry.
Yeah. There we go. All right, great to have you back. Mr. Murillo, tell us about case 17.
On May 18, while conducting an annual housing inspection, a case was opened for not having sliding door screens. I had an inspection on June 8, 2022. There was no compliance. Notice was posted on March 3rd, 2023. Also mailed on March 9, 2023. As of my final inspection, there was no compliance.
Show me the photographs reflecting the violations, if any.
Yes, 1 sec.
They're beautiful windows. They just don't have any screening, and the code requires that there be screening on all of these sliding glass doors and windows. Perhaps some people don't know that. I certainly didn't know that, but the code does indicate that screening is part and parcel of those windows and doors. Any issues there, Sylvia or Lior?
Yeah, so I want to say a couple of things. First, it didn't show you the whole building, but this is a well maintained building, probably one of the nicest one in North Miami. Everything is done by code and permits and all of that. all the windows, like you saw, and the sliding doors are hurricane-proof and done with a permit. When it was done, there was no requirement for a screening. So no trucks, nothing was put. We don't even know when the code was changed that we can even tell you. We were trying to find, we reached out to the city. We didn't get any responses. We can show you the exchange of emails and all of that. So the challenge here is that we brought the professional companies and all of that to see if we can add it, and it's impossible. So for us to add now a screening, which, by the way, is not required by our tenants, they don't want it, but let's leave it on the side, it means that we will need to replace the entire sliding doors. And that's a heavy, heavy expense after we did everything by the book.
Yeah, I have always have had a concern, certainly on some of these cases on the agenda today. If the window or the sliding glass door structure mechanism has been approved as is by the Miami-Dade County Product Approval Department, and then they get installed and the property owner gets a CO, how do we then come back to the owner and say, well, now you got to put screens on these, hopefully they're in compliance in every other respect, probably impact windows, is that what the code requires under these circumstances?
Well, one of my first question is, when did you guys acquire the building, and when were the windows installed?
We acquired the building, I think...
It had to be post 2015, because from what I recall from the last case, there was another owner.
We acquired it in 2018 or 19, if I'm not mistaken. I can verify it.
Okay.
And it was done by the previous owner.
Okay, so can we, because those doors look brand new. They don't look like they've been when did you install those doors and windows?
No, they were installed by the previous owner.
Okay, so my first question would be, because that ordinance regarding screening has been a city ordinance since 2014. So depending on whether or not, in fact, the windows and doors were even permitted would be my first line of questioning or, concern. We're based on the fact that they're there, we just assume that they were done with proper permits, right? But that's not a new ordinance. It's been adopted since 2014. So I'm happy to look. We can table the matter and look into this a little further, magistrate. But I don't want to hash it out. We've already, kind of been. It's, on the matter for quite some time. We can look into it, table it. But I do want to put on the record, the ordinance has been here since 2014. So if the work was not recent work, I would suspect that, whatever it was done, I'm hoping it was done with a permit, because that would be the issue.
We reach out to the previous owner, and this is what was told to us, that everything was done with a permit, and you can come and check with a certified license.
That's possible, right? But that doesn't necessarily mean that there was even a CO. I mean, there's circumstances where, title transfers, and I hate to go now dig up and see whether or not a CO is even really actually issued by the city. But, all of these things raise question. If you guys didn't, in fact, do the work yourselves and you purchased the property, unfortunately, you inherit the issues. So we'll do the background research. I'm happy to take your information and we can circle back with you, the building official and I, so that we can kind of, dot our I's and cross our T's as it relates to all of the issues that have just been raised.
Yeah, right. Because if I can say something, we don't see anything that it's, let's say, like a hazard, having this screen, beside the fact that we will need to change and add like a big truck over there. We make it complicated. And they really don't use those doors at all, those tenants. They don't open.
I understand. You know, I think it's best that we table the matter, and we can have a conversation once we've kind of done the research, and we'll circle back with you guys on, you know, what the research reveals.
Yeah, I think that's the best approach. I want to end this conversation because there's a lot we don't know, and one of the things I don't know, which I think you ought to take a look at, is if it turns out that the code applies and they need to put up screens, and it's impossible unless you just replace every door and every window at an exorbitant amount of money. Is there the ability to perhaps get a variance? And if the planning and zoning will consider that if it's necessary, because I wasn't aware that screens were required. You know, screens are required when, you know, you have sliding glass open and, you know, you get mosquitoes, you get bugs, you get stuff in, so you put up a screen. But if it's locked and you can't open it, then why put up a screen? You know, just speaking as a layman. Anyway, look at all the issues that Ms. Patterson identified, including whether or not it was CO'd, and whether there's a this is all a you know, a window structure that comes this way without a screen, that you can't put a screen on top of it. Whatever the issues may be, you know, plus or minus, whatever. Let me hear at my next calendar what the result is. Okay.
Okay.
Perfect. Yeah.
All right. Next case.
I think we had another one about the.
Oh yes, the exterminator.
Which we have an agreement. We do take care of this.
Again, we have a license. We have a company. We can show you that we have a company that visit the venue, this property on a monthly base, doing it.
Well, Mr. Officer, when you did your inspection, were you furnished with a copy of the exterminator report?
I didn't receive any report.
Well, all you have to do is show the extermination report to the code officer, and the violation will go away. So, do you have it with you now?
I have it. If I can share my screen, I can show it to you guys.
But do we supposed to post it somehow on the property, the information of the company?
No, you guys just need to send it over to the code officer. I think that it seems as though you guys, all we need you to do is be in contact with your code officer. So provided you had done that prior to today's meeting, we wouldn't even be discussing the matter today, but send him an email with a copy of the extermination report. If in fact it is dated, you know, as a current extermination report, that would satisfy that section of the code. So magistrate, we can table that matter as well, pending them sending the email with the supporting information.
We will table that as well. Thank you very much.
Thank you.
Just a quick comment, a side comment. We were aware of the two last violations, the one with the screening and the one with the extermination. Those were brought to our attention. We weren't aware of the other two that you mentioned.
Yeah, we understand. Some people don't think that they need one because they get one from the county, but every city and town in Miami-Dade County does require those two.
No, I understand, but my point is that we weren't even aware that we are in violation of this.
I know that. And that's understandable.
We didn't get a notification, I'm saying, from you guys, not email, not mail, nothing.
You were posted on the property. Also, when I did the owner housing inspection, when you received the report, when Ms. Sylvia contacted me about the sliding doors and everything was mentioned on the report when I did the AHI. It was posted and mailed to the property right there.
You see that little paper there on the side of the box?
Yes. Yeah. There were two violations there, but okay. Don't worry. It was just a side comment.
Anyway, all right. Let's move on to the next case. We're running a little late.
Thank you.
Thank you.
Okay.
Item number 51. Are we going to call Richard Cristiano? Item number 51 is Anadu Crop LLC, case number SDNOV 2022-00745.
Hopefully he's here this time. Richard Crisanino? Richard Crisanino, are you there? We're happy we can hear the case magistrate. I mean,
there he is.
He has access into the meeting, so after
seems like a pretty straight run-of-the-mill issue. Mr. Crisonino, we're going to start without you if you don't move on. If we can't hear you.
Maybe he needs some interpreter.
He needs an interpreter?
Oh.
Hi. There he is.
Sir, please raise your right hand.
Is this for Xanadu Properties LLC?
Yes, it is.
I'm awfully sorry to keep you waiting. Richard Crisanino, sole managing member, attorney for Xanadu Properties LLC. The building is at 600 Northeast 142nd Street.
You need to be sworn, sir.
I think he said he's an attorney magistrate.
I do.
Okay, all right. He's also the property owner. Okay, as an attorney, you don't have to be sworn. You're acting as an attorney. Okay, so that's good. Do you understand the nature of the charges?
I do.
All right. Are you contesting these charges?
No, the property's in total compliance. I sent the inspector an email on Thursday and over the weekend saying that the remedial work had been done, which is repairing the container dumpster and putting in 2 new gates. That's been done.
Do you have any proof, any evidence? Pictures?
No, I didn't. It was just done. I was pulling my hair out to get to somebody to do it, and they finally did it on Saturday. So the answer is no, but I did send an email to the inspector requesting that he re-inspect, and I'm not sure whether he had time to do that or not.
Probably not. These things come in a week before, so we don't wait until the last minute to get
I understand.
This. Let me just, because I know I've read the file, I just want to remind myself of what that dumpster looks like. Can you post the pictures? Okay.
The wooden areas have been repaired. I actually got a hacksaw and took down the metal portions, and now there are 2 large doors that enclose the front of the dumpster enclosure.
Were those doors installed with permits?
I was going to do it myself because I couldn't get anybody to even give me a quote to put the 2 doors up. So I was actually at Home Depot on the 17th buying, thinking what materials I would need so that I could do it myself. And I got a quote that day. So the answer is no, the work was just done and I couldn't get anybody to do it. And I don't think I need a permit because the notice of violation didn't require a permit. It said just make the repair and replace the doors. So it didn't indicate that I needed a permit, and I didn't get one.
Well, does it need a permit or not?
It depends on what he did. I mean, at this point, we don't know what he did. I would say, magistrate. Well, I would ask that we would enter an adjudication and take a look at what's going on at this point. By the property owner's own admission, there was some repairs made. Some doors were installed, gates removed. I think that it's clear that the enclosure was in need of repair, and the request was to repair it per code. We don't know what the status is.
All right. Until the city is satisfied and I'm satisfied that there has been full compliance with the city code, meaning that not only the enclosure, but that the enclosure as built was in compliance with the code. It may be that you don't need a permit, but it has to be done a certain way. So until I'm satisfied, I'm going to keep the case open, but I'm going to give you until May 18th to demonstrate to the satisfaction of the city that everything's been done correctly. Whether it needs permits or not, that's not my call. That's the call of the building official. His opinion on that trumps my opinion, and so I'm gonna basically find that there has been a violation, and that there will be an adjudication in favor of the city with a compliance date of May 18th. In the event that there is no compliance, there will be a daily fine of $150 until the violation is abated.
Can I just contact Inspector Murillo and ask him to do a reinspection? Will that satisfy the situation?
Well, he's going to go back and do the reinspection, and then he'll come back. Either there's compliance, or if there's no compliance, then it'll come back to me on May 18th or thereafter for a further order.
Okay, I'll re-email the inspector to do the reinspection as soon as possible.
Yeah, absolutely. And then he will have to determine, based on his communications with the building official, whether permits are necessary or not necessary for the work that was performed. And if it was performed without a permit, you will be given an opportunity to get an after-the-fact permit.
Well, once again, the notice of violation didn't require a permit. So as far as this hearing is concerned,
we're not gonna talk about that this hearing, and I'm not going to hold you responsible for any permit violations. All I'm suggesting is that by the next meeting, we will know whether or not you're in compliance. They may issue another violation if you did it without a permit. They have to issue a new violation if you did it without a requisite permit, or if the installation doesn't comply with the code. Either way.
Very good.
Okay. All right. Good luck to you. Good afternoon.
Thank you.
You're welcome.
Item number 5, 130454 Coronado LLC. Case number CEBPR 2023-00792. Officer Jose Perez.
Well, just for clarity, we don't have anyone else here on behalf of any other property, so all of these others are unrepresented. Can we go ahead and dismiss the translators also?
Go ahead. Are we still going to hear 5? Number 5? Are we still going to hear number 5?
Yeah. We still have other cases to be heard. What I'm just stating is that we don't have anyone else here. All the other properties are unrepresented. So okay. I just wanted to release the translators, and we should be able to breeze through the rest of the items, the rest of the agenda.
You have a good afternoon.
Anybody here on behalf of property owner at 1305 Coronado Terrace?
No, we don't have anyone else here to magistrate. It's just us.
Okay, well.
Jose,
let's hear number 5.
If we're ready, we're hearing the case at 13045 Coronado. This case is as it relates to work without permits, demolition that occurred at the property. The property was originally cited on January 24th, 2023. A stop work order was posted at the property, and the workers were dismissed from the property. They were vacated, and they were educated that they cannot continue to work as no permits have been obtained. Now, after that matter, there had been quite a couple other interactions where they had continued to do work at the property, disregarding the stop work order that was placed at the property. The property was sent via certified mail to not only the property appraisal address, but also to that of the registered agent. The registered agent was also mailed, and for the hearing, it was posted on March 13, 2023. It was also sent via certified mail, And at this point in time, no permits have been obtained for said construction without permits. At this point in time, the city is requesting an adjudication as well as a monetary fine for the activity.
I just realized that the gentleman we heard earlier, he owned this house as well.
Yeah, we heard
the charters.
We heard from a Zimmerman previously.
Did he know he had another case on the agenda?
Yes, he was aware.
Well, to put it mildly, this house is a disaster. It looks like a bomb blew it up. So
it happens to be right next door to the property with the charter.
Okay. So you're asking me to impose a fine for
a daily fine
for what has already happened, and particularly disturbing is the continuation of work after a stop work order was issued by the building official. So that's one issue, and then the next ask from the city is that I do what?
Just an adjudication and just a fine at this point in time.
Is there something that they need to do within a certain number of days? Or, I mean, you can't leave that property there the way it is.
They need to obtain the permits, the after-the-fact permits for the demolition, which they have not done so as of yet.
Okay, so it's really a two-part order based on the unrebutted testimony of the city's code compliance officer and the photographs that I've seen. And I find, first of all, that the action of the property owner in demolishing this entire property, just about, and furthermore, continuing to demolish and do other things in spite of a stop work order, is subject to a $5,000 fine. So that's one part of the order. The next part of the order is that, based on the evidence presented, the property owner needs to get a demolition order permit from the building department. And I am going to require the property owner to obtain the permit, demolition permit, by May 18th, 2023, the abatement date. In the event of a non-compliance, there shall be a daily fine of $1,000 until the violation is abated. Is that clear?
No.
Not clear.
You're fining him $5,000.
I'm fining them $5,000 for what they've done up to this date, demolishing without a permit. And then continuing to do work after a stop work order has been in place. For those actions, a one-time fine of $5,000.
So it would be, Peggy, so the order would be a one-time fine for $5,000, and in order to comply with a $1,000 daily fine if they fail to comply.
That's right. If they fail to get a demolition permit.
Mm-hmm.
Okay, I'm going to see how I'm going to put it in our system, because I'm not sure if Eden will be able to support it, but I'll figure out what it is.
Yeah, we can try to work on that.
Thank you.
All right. Next.
Item number 8, Angel Moro, case number CBPR 2022000577. The officer, Shannon Sanders.
Ms. Sanders, let's hear from you.
Shannon Sanders, City of North Miami Code Compliance Officer. This case has been dismissed for property address 185 Northwest 124th Street. Upon reinspection, the carport structure has been completely removed. Therefore, again, the violation has been abated.
Yeah, I just want to remind you, Ms. Sanders, not in every case, but in a case like this, it would be helpful if you included in your file photographs of the structure in question, so it'll make it easier on me to visualize what the problem is.
Okay.
All right.
The case complied, right?
Yes.
Item number 9, Arnell Jean Lewis, Iva St. Ville, case number CEODS 2022-00164. The officer is Gennaro Murillo.
Mr. Morello, you're on.
Gennaro, you're on mute.
I'm sorry. Good afternoon. Officer Murillo for the City of Miami Code Compliance. On June 13, the property address on 921 Northeast 141st Street was asked to remove items that were stored on the front, rear, and side of the property. I had a reinspection on July 1st, 2022. There was no compliance. A notice to appear was posted on March 2nd, 2023. On March 9, the notice to appear was mailed, and I had a final reinspection on March 16, 2023. There were still items on the front of the property.
Yeah, it looks like a garbage dump. Anyway, I will enter an adjudication based on the testimony of the city's code compliance officer and the photographs received. Proper notice having been given, I find for the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated. Next case.
Item number 11 and 12, Emer LLC, case number CEFOB 2022-00361. And item number 12, case number CEZCU 2022-00655. And the officer, Gennaro Murillo.
All right, let's hear the BTR case first.
These
11.
two cases are in compliance. They have already been closed.
They're closed?
Yes, they're in compliance.
All right, we'll be dismissing cases 11 and 12.
Number 22, Janvier Rodriguez and Zola Gomez. That's item number 22 and 23. The officer, Gennaro Murillo, case number CEBPR 2023-00805. And item number 23, case number CEODS 2023-00238.
All right, let's hear 22.
Which one, I'm sorry, we're listening to?
22, 1410 Northeast 141st Street.
Okay. Good afternoon, Officer Murillo for the City of Miami Code Compliance. On February 10, 2023, a violation was found based on a complaint from a resident for the property on 1410 Northeast 141st Street to please obtain permit for the shed that was installed in the back of the property or removed it. There was I had a reinspection, I'm sorry, for February 23, 2023. There was no compliance when I did my reinspection, and a notice to appear was posted on March 3rd, 2023. And there was also a final reinspection on March 16, 2023. Let me mention that they applied for a permit on the 8th, but it's still pending.
Okay, with that said, Magistrate, can we table the matter for 30 days until the next?
Let's table the matter on the shed, which is item 22. How about number 23?
May I proceed?
Please.
On February 10, 2023, a violation was found on the property 1410 Northeast 141st Street. There was an outdoor item store on the back on the property. I had a reinspection on February 23rd, 2023. There was no compliance. The item was still over there. The notice to appear was posted on March 3rd, 2023. On March 9, it was also mailed. And I had a final reinspection on March 16, 2023, where there was still no compliance.
And have you had any conversations with the owner about?
Yes, they said that they were going to call me before the hearing for items that they were still were going to remove, but haven't heard from them again.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented, depicting that the cited violations still exist, that proper notice has been given, I find in favor of the city, enter an adjudication and set an abatement date of May 18th. In the event of non-compliance, there shall be a daily fine of $1,000 until the violation is abated.
Item number 25, Kathy Mary Clements, case number CEGMP 2022-00110, and the officer is Jamal Murillo.
Officer Murillo, City of Miami Code Compliance. On June 10, I opened a violation for the property of 1085 Northeast 143rd Street to pressure wash the driveway and pressure wash and paint the walls and front step as needed on the property. Out of inspection on July 1st, 2022, there was no compliance. A notice to appear was posted on March 3rd, 2023. On March 16, which I had my final inspection, the property owner called saying that she was going to paint the house before the hearing and haven't heard from her. So the violation is still on the property. There's still a violation on the property.
Yeah, what I found most concerning were the steps.
Yes.
They looked like they really needed some work. I see what you're showing me on the side, but I think the steps, the front,
it's not crack or anything like that. It's just like mildew and stuff.
Yeah, like mold, mildew.
Yeah,
and it definitely does need work. So based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist, proper notice has been given, I find for the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Number 26, Lautaro Deciano, case number CEGMP 2022-00113. The officer is Jamal Murillo.
Officer Murillo, City of Miami Code Compliance. On June 23rd, 2022, the violation was observed while I was patrolling the area. The property 941 Northeast 139th Street was I opened a violation to repaint or pressure wash as needed the entire property, including the main door. Out of inspection on July 5th, 2022, there was no compliance. A notice to appear was posted on March 2nd, 2023. It was also mailed on March 9, 2023. As I was final inspection on March 16, 2023, there was no compliance.
Any conversations with the property owner?
No, sir.
Is there somebody living there?
Yes. Well, I had a conversation last year because they had other violations in the property, which they complied, but not with the painting of the property after that. Haven't heard from them.
Okay, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 27, Lazaro Robina. Case number CBPR 202200582 and the officers Chenaro Murillo.
On June 21st, 2022, a violation was observed while patrolling the area. I observed a violation on the property 1015 Northeast 145th Street. So please obtain an after the fact building permit for the white metal fence that was built in the front of the property. I received a call on June 28, 2022 from Mr. Lazaro asking for an extension. An extension was granted until July 29. On July 29, there was no compliance. No application was made. On March 3rd, 2023, a notice to appear was posted. It was also made on March 9, 2023, as a refinery inspection. There was an application submitted on March 14, 2023, but there haven't been no comments from the building department, so it seems like they only applied, but there's no movement on the application. Also, let me advise that this property and this property owner was also cited on October 27, 2022 for building a wooden fence with no permit. So this
on
is
on the same property?
Yes, this is a repeat offender. It was a ticket was issued on October 27, 2022 for also a wooden fence that was built on the property with no permit.
And was that violation was corrected?
No. So then the white fence was built and also with no permit.
So you got two fences built without permits?
Yes.
Okay, and do you say they filed for an after the fact building permit on one or on the two?
They apply an after the fact permit for this particular case, for the white metal fence.
Okay, you're not. The problem I have is that you're not charging him on Lazaro. You're not charging him on the pre-existing October 22nd violation, are you?
No, this is our case that was open before for a previous officer.
Okay,
the one mentioned on October 2020.
That was not the prior violation was not corrected either.
No.
But this case, magistrate, is not being brought as a repeat offender. It wasn't cited as such, so we're not bringing it as such.
Oh well.
Okay. Well, at the next hearing, are you going to bring the other fence?
The code officer would. Yeah, it sounds like it was something that they were cited for previously. I don't know enough to speak about it.
We'll leave that open. Let's just deal with the one in question, and as to that particular white fence that you showed me, based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 28, Lee and Angel Silva. Case number CEBPR 2022000583, and the officer is Gennaro Murillo.
Okay.
On June 21st, a case was open for the property address 850 Northeast 142nd Street. To obtain an after the fact permit for the stucco work that was done in the front of the property. I had an inspection on July 1st, 2022. There was no compliance. A notice to appear was posted on March 2nd, 2023. It was also made on March 9, 2023. I had a final inspection on March 16, 2023. No application of this has been made.
Okay. You have any pictures?
Yes.
This is stucco work on top of the door, right?
Yes. Yes, Your Honor.
Okay, and then you got some plywood on top of that. Is that part of it?
Yes.
Okay. Any discussions with the owner?
No, they have never contacted me, or I haven't seen them, nothing.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of May 18, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 29, M&J Asset Managers 1 LLC. Case number MHVIO 2020000141, and building official Mayor will be the one in this case.
Good afternoon, Special Magistrate.
Good to see you again. You had a good lunch?
Well, it was quick. It was quick.
All right.
Okay, so with this property, the property was posted on March 8, 2023 for appearance. The minimum housing officer at the time, Gary Beswick, received a complaint from former officer Aaron Barber on February 25th, 2020. Officer Beswick went to the property and observed partial demolition of home, alteration, renovation in progress without permit. Officer Beswick spoke to the man doing the work and advised him to stop all work until all required permits were obtained. At that time, the man was also installing a new electrical panel. Officer Beswick spoke to the property owner at the time and advised them of the violation in progress and the requirements for the solution. Mr. Leopold Manuel with M&J Asset Managers 1 LLC acquired the property in 2021, and as a condition of the reoccupancy, he applied for a permit for new addition of 383 square feet and renovation. On December 16, 2021, due to the nature of the work, this property was placed as a substantial improvement. So the permits were submitted, but because of the flood implication, the substantial improvement, it kind of there were some extra compliance items that they needed to do. So after much conversation with building department staff, a flood officer, and also the flood consultant, it was determined that a acknowledgement of non-compliance and future flood damage conditions and restrictions would need to be signed by the owners. And he's since brought that in yesterday. And as it stands now, the permit is still pending a structural comment and a building comment to be resolved in order for it to be approved. But this case has been here for a while, so there still has those two items to address, and we want to kind of adjudicate, and hopefully soon they'll get the permit in, so that way they can.
All right, I have a couple of questions.
Yes.
the ugly pictures of the demolition are dated 2020. And then in 2023, I saw a beautiful picture of a beautiful house.
Correct.
Okay?
Correct.
Now, all of that work that took place to build that house was done without permits?
Correct. Yes. Correct.
And nobody caught it?
Well, I believe it was the property was cited at the time, so for some reason they proceeded, but in the process of trying to submit for permit, because of the substantial improvement of it, they had to comply with flood.
But did they have a permit at all to finish the house?
Well, not to finish the house. Actually, the permit. I think the permit was submitted in 2021. On December 16, 2021, the permit was submitted. But I'm sorry, December 16, 2021, the permit application was submitted, but no permit as of now.
No permit issued.
No permit issued because along the way they had some issues with flood compliance.
Okay, so the flood issues have been resolved?
Correct. Yeah. As of yesterday, he returned to the building department the signed acknowledgement for the non-compliance and future flood damage condition.
So does that mean that they can now get a CO?
Well, what it means now that they just need to resolve the structural comment and the building comment. So that way, when they resolve that, the permit could actually be issued, then they would need to call for a final inspection. So that way it would they need a separate permit for the roof? I believe he acquired a permit for the roof already.
Okay.
But the addition wasn't. It's still in application phase.
So where it stands today, there's still some work to be done. There has to be a final inspection, and then after a final inspection, if everything is fine, then you issue a CO, and that's the end of it.
Yeah, the CO for the addition, for the new addition.
Okay, so I'm inclined to issue one more question.
Yes.
When they bought the property from the prior owner, was the prior owner the one that was doing the unpermitted demolition?
Yeah. Yes. So back in on February 2020, it was the previous owner at the time that was doing the demolition. So I believe the
How would
person
they have been able to transfer title with the property like that?
It was I guess it was a private sale. It was a private sale where I guess they didn't go through the reoccupancy process. And just the property kind of just changed hands. I think it changed hands twice, I believe.
Yeah, all while the property was in the process of demolition.
Yes, correct. Demolition slash the.
Well, the existing owner should know better. Number one, he's buying property that is being demolished without a demolition permit, and he's purchasing property that is not being where there is no certificate, a transfer certificate of reoccupancy.
Correct.
So what I'm inclined to do is I'm willing to I'm willing to impose a one-time fine for all of the issues that arose up until the gentleman finally filed some paperwork with the city as required to do because of the prior demolition. And then then you're suggesting that I adjudicate him guilty for what?
In terms of for the violation, and because of the nature of the work, this agreement took some time to be drafted, because it was several discussions, and also with the city attorney, we had to kind of involve them in terms of the document.
All right. So am I running in, and city attorney, am I out of line in imposing any fine if you and the property owner have been in the middle of negotiations which led to the final resolution, not final, but almost at the end of a process where we end up with a nice looking home? Is there an agreement that I should be looking at prior to imposing a penalty?
I mean, it sounds very dangerous territory. I would just ask the building official, is there like a list of the different permits that were needed? Because it must be like a long list so that we can have a better idea, and then magistrate, based on that, you could come up with whatever number you feel that is reasonable as a one-time fine, or it could be a daily fine, whatever you want to do. And that's the only way I see that this could be resolved.
And if I may, magistrate, I just kind of want to just bring us back to, just kind of the matter at hand. The property was cited in 2020. A stop work order was posted on the property. Whether the property transferred, or not, in the midst of that, a stop work order had been posted. To date, there is still no permit on file. The nature of the violation is construction without permits. So at this time, they've clearly continued to do the construction even beyond the stop work order being posted. I think that, I think that the city has definitely met its burden of proof in terms of an adjudication and whatever fine your magistrate deem appropriate. I don't think that there's I think it's pretty cut and dry, frankly.
Well, I agree. It's just, how do you apportion the actions of the various people, and mindful that we ended up in a better place now than we were 2 years ago or 3 years ago.
Yeah, but there's a process to get there. And clearly he didn't follow it, and he took the property knowing that, knowing or not, I don't know, that there was some outstanding permits that needed to get paid for, and we don't know if the property is I don't know if up to par is the word, but if the electrical is right, or if anything was done with the contractor. So it's really, I think he's on the hook. It's nobody else.
Yeah. It's too. Go ahead, sir.
And just to clarify, that agreement is just for flood compliance. So
okay.
Yeah, it's just strictly flood compliance. So that was the main component.
Had the city issued the violations and imposed a lien 2 years ago when this property was a mess, this new owner that just came on board would have been required to pay off that lien as part and parcel of purchasing the property.
Well, actually, the owner, based on, the property records, the property transferred in September 2021, even before, they're the ones that submitted for the application for the permits. So whoever it is that acquired the property, they must have acquired it while it was in its demolished state. Correct. And they also applied for permits and have since repaired the property without having been issued any permits by the city. I guess they, have entered into some agreement regarding the flood issues, but nonetheless, they were quite aware of what was going on.
Yeah. So in light of what you're telling me, which I agree with, I believe it is appropriate to impose a fine for all of those things that were done wrong. That's easy. The next question is moving forward to resolve whatever pending issues may be. What should that order be?
I would say a month. Hopefully, within a month, we'll be able to clear up the structural comments and building comments, which are not that they came a long way. which is not, I think, within a month.
Yeah, I see the question. I mean, I think, seeing as it's kind of one of those things, right, where the house has already been, it's already been remodeled. We're at the cup end of the permit process, but still, in fact, they don't have the permits, magistrate. I mean, I would say that the city's recommendation would be that you go forward with what you were recommending originally, which is the one-time fine and the order to comply. It does appear as though they are looking to finalize the permits. So I think that given the 3 years that the property was out of compliance in terms of, permits and things of that nature, the one-time penalty would satisfy. And I think the property owners would have to agree that, they did do the construction without proper permits, despite the stop work orders, et cetera.
I think we did this earlier. We bifurcated the order such that the first part of the order is, a one-time fine of $5,000 for the work for all the things that were done incorrectly from 2020 until now. So moving forward, from now on, I will enter an adjudication in addition to the $5,000 fine that says that the property owner is guilty of doing work without permits because they didn't obtain permits to do all the repairs that are underway right now, and set a compliance date of, I would say, June 15th to get everything done. And in the event of non-compliance, if they don't have a CO by June 15th, I will assess them with a daily fine of $500 until the violation, the building without permits violation, is complied with. Does that make sense?
Yeah, we'll work together to put something like, we haven't done those types of orders in the past, but we'll figure it out.
Okay, because there are multiple things they did wrong. So I'm trying to isolate what was wrong early on, 2000, all the stuff that they did, even after a stop work order. And I saw the pictures, they look horrendous. So for that work, there's a fine. And now we're going to say, going forward, if you don't do what you need to do by June 15th, then we will start assessing you an additional fine of $500 a day. It's a two-part order.
We got it. We'll work on it.
The attorney, I think maybe you can weigh in on that.
As to the order?
Yeah.
Yeah, that's fine. I mean, it's fine. I don't see any issues with that, with a two-part order. Yeah, no, it just, the problem is that we've never done this before, and we want to make sure that it's done right. And now we have two cases today where that came up.
Yeah, we'll work together internally, magistrate, to identify how to execute, but it's fine.
Yeah, or I don't know if you want to do two separate orders. I don't know, whatever it works.
Okay.
Okay.
All right.
All right. Thank you. Thank
you, sir.
Item number 31, Ocho Moore LLC, case number CERCV 2022-00247, and the officer Gennaro Murillo.
Did we get 30, Peggy? I'm sorry.
31.
No, I don't remember 30.
30, Mia Housing for LLC, case number MGL 2022-00450. That case is in compliance.
Okay. All right. Sorry. Go ahead, Gennaro.
Yes. Good afternoon, Officer Murillo for the City of North Miami Code Compliance. On June 13, 2022, I opened a violation to the property address on 910 Northeast 141st Street. It was to remove an RV that was parked on the rear of the property, or to obtain a variance from the Community Planning and Development Department. I had a re-inspection on July 1st, 2022. There was no compliance. I posted the notice to appear on March 2nd, 2023, which I also made contact with the property owner that day. He said he was going to remove the RV. The notice to appear was also made on March 9, 2023. On March 16, 2023, I had a final inspection, and the vehicle was still on the property.
You said you did discuss it with the property owner or not?
Yes, when I did the notice to appear, when I posted, I made contact with him. He said he was going to remove it. When I did my final inspection, the vehicle was still there.
Okay. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violations still exist, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Thank you.
Item number 34 through 42.
This is the Sutton House.
Sutton House. Case number for item number 34 is CEEXC 2022-00027. Item number 35, case number CEFOB 2022-00366. Case number for item number 36, CEMHE 2022-0039. Item number 37, case number CEMHS 2022-00458. Item number 38, case number CEMHS 2022-00459. Item number 39, case number CEPKS 2022-0005. Item number 40, case number CEWWC 00080. Item number 41, case number CZCU 2022-0664. And item number 42, case number CESCN 2022-0021. Shannon Sanders with the officer.
Is it my imagination or this condominium is before me just about every other hearing? Sounds very familiar. Have I ruled on these cases before?
They have multiple properties.
Different property? Okay, let's start with 34. The walls have to be repainted. Who's gonna testify about that?
Shanna Sanders, City of North Miami Code Compliance Officer. Special Magistrate, I would like for this, along with several cases, to be tabled.
Honestly, I have not.
So I have no.
You're breaking up. I can't hear you well.
Special Magistrate, for this case, along with several other cases dealing with this property, I'm going to ask that we either grant them an extension and or table them. I have not been able to re-inspect this property, so honestly, I have no update as to what's going on since I initially posted the notice to appear. So I'm uncomfortable with even giving testimony for the majority of these cases other than 3 that I would like to move forward with, but this one, I would not like to hear it. I'm going to ask for it to be tabled.
Well, what I find disturbing is that here we have a condo association with multiple officers and directors, all of whom have money invested in their units. They're being cited by the city of North Miami. And there's a whole bunch of alleged violations and nobody shows up. That's what troubles me, that, you know, it's like they don't care, like the orders of the city don't mean anything. So yeah. I understand where you're coming from, but somebody needs to tell these condo unit owners that their money and their units are at stake. And if they don't show up, to me, that's evidence that they're admitting their guilt. So
Magistrate, I would also ask, Shanna, why are we tabling?
Because I haven't done I haven't had the time to do the reinspection. I haven't been at work since March 15th. I have not been able to do any reinspections. As you see, Magistrate, as well as Director Patterson, none of my pictures have been uploaded for any of my cases. Today is my first day back, so I don't have any updates. I haven't done any reinspection since the 15th of March.
Okay, well, I would have wished that you would have made us aware so that we could have tabled. So what numbers need to be tabled?
I would say cases 34 for the exterior of the property, case number CE.
Just give us the number, please.
Page 34.
Case 34.
Page 37. Page 38. Page 39. Page 40. And page 42.
And why wouldn't the other ones need to be tabled?
Because the other three that I have here are for certificate of use, business tax receipt, and for extermination reports. Those are things that I could have easily looked in the computer to see if the business tax receipt and or certificate of use has been submitted and or if an email has been sent to me for the extermination report.
Okay, so Magistrate, if we could table those item numbers that were mentioned through the next hearing date.
All right, so ruled. We'll table those items. Let's hear the ones that we can hear. Is that starting with 35?
That's correct, with the business tax receipt.
They don't have one.
That's correct. Exactly. They do not have one.
Okay, you sure?
I looked in the computer this morning, and they do not have one on file.
And
at all for this property.
One is required even if you're a condo.
Per community planning and development, yes.
Okay. All right. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented today depicting that the cited violation still exists, proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. And in the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Magistrate, I just want to point out something. We currently have an appeal for a notice issue. A property similar to a condo. So I just want to point out that going through notice is important. I just wanted to put it out there.
I absolutely agree. I'm glad you brought that up. I assume always that when a code officer presents that and they show me evidence in the file that letters have been sent, papers have been posted on a wall, I assume that that's evidence of notice. So I hope it's not one of my cases that's being appealed. But
no, it's not. It's not.
But I want to make sure from this officer and from all officers that when you come before me that you have made every effort and are completely satisfied that all notice provisions have been complied with. Right, Ms. Sanders?
That's correct.
Okay. So we're done with the business tax receipt case. Let's move on to the next one. Is that the extermination report?
Yes, case number 36, CEMHE 2022-00039 for the extermination report, property address 1885 Northeast 121st Street. This property was initially cited January 30th, 2022, whereas I was doing my annual housing inspection. Through the annual housing inspection, I noticed no extermination report was posted in or provided to me. Notices of violations was mailed out to the property. As already stated, they have several violations. I have not had any contact with anyone from this building in particular.
Who have you been talking to at the condominium association?
I have not had contact with anyone for this property because, you know, as you stated, there's several buildings in this little in this particular area. They have 1885, I believe 1895 is several buildings in this little 121st and 120th Street area. I can say when I first did the annual housing inspection, it was a woman there who identified herself as the manager. But I'll be honest enough to say the conversation was very short because she was jumping back and forth to several buildings because it was several of us officers all doing annual housing inspections at the same time. So by the time I finished my building, she was still at one of the buildings across the street. So we didn't have any further conversation other than her identifying herself as the property manager and to more so pass on the AHI once we were complete.
Okay, I accept that. So there was no extermination report submitted, correct?
That's correct. As of my last reinspection, looking in the computer today, nothing has been submitted to the city regarding an extermination report.
All right. Based on the unrebutted testimony of the city's code compliance officer, the evidence presented depicting that the violation still exists, that proper notice has been given, I find in favor of the city enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. I urge all condominiums, and the word should get out, that I have no sympathy for condominium associations that are not maintaining their properties correctly in accordance with code, and then when noticed, fail to appear before the special magistrate, knowing the seriousness of some of these violations. So I can't emphasize enough the importance of showing up for these meetings. All right, next one.
My last case for this property is page 41 or case 41 CEZCU 2022-00664 for not having a certificate of use. Again, on that same date, 6/30/2022, while doing my annual housing inspection, I noted that no certificate of use or business tax receipt had been posted at the property. Had a brief conversation with a woman who identified herself as the property manager of Sutton House as of my last reinspection. And looking in the computer this morning, I still don't see a certificate of use on file for this particular building.
Okay. Based on the unrebutted testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists, proper notice having been given, I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. The event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Item number 47 through 50. Venice Lane, Inc., CO US Management, case number MSBIO 2022000438. Item number 48, case number is MSBIO 2022000440. Item number 49, case number MSBIO 2022000445. And item number 50, case number 2022000447, and the officer is Jose Perez.
All right, let me hear from the officer.
Good afternoon. Jose Perez, co-compliance manager for the City of North Miami. Today we're hearing the case as it relates to the property at 1755-1765 Venice Lane as it relates to several violations. The first violation is for window screening. There are several damaged and missing throughout the entire building. The property was originally posted on July 2022. Shortly thereafter, the posting, I spoke with the condo president, George, who requested an extension until September 2nd, 2022. That extension was granted. As of that reinspection on September 2nd, 2022, Compliance has not been met. I tried reaching out to the condo president several times with no avail. Unfortunately, the property is still in the same condition as of March 7, 2023, and has not secured their screening as required by the ordinance. The property was posted. It was also sent via certified mail. And at this point in time, the city is seeking adjudication as well as a fine set until they do repair and replace the damaged and missing screens for the property.
Can you briefly show me a couple of photographs of the screens you're talking about?
What case number is it? I'm sorry.
This is number 47.
Several damaged and missing throughout the entire building. Okay, that rings a bell. I saw these pictures before. Okay, you don't need to go any further. Based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
The next case, number 48, as it relates to the property, is for business tax receipt. Same scenario as the previous case. Spoke with the with the condo president, George, who requested an extension until September 2nd, 2022. They had not applied for or obtained the business tax receipt with the city of North Miami. As of my final reinspection, they still have not obtained it. The property was posted. It was also sent via certified mail. As it relates to the hearing that was done on March 7, 2023. And that is my reinspection. They have not met with compliance. At this point in time, the city is requesting adjudication as well as a fine set until they do obtain their business tax receipt.
Is the main reason they can't get a business tax receipt that they have these other issues that they need to address first before they get a BTR?
Not at all. They haven't applied for it at all.
No, but I know they haven't. But if they were to apply for a BTR, would they get one in light of these other violations that are still outstanding?
I believe so. Where it would get a little tricky might have been the CU. But those are tied hand in hand.
Typically, they're not going to issue pending violation. Yeah. Typically, there's going to be a problem with them getting the licensure if there are pending violations. But we wouldn't know firsthand, but there tend to be some delays when there are violations.
The fact of the matter is they don't have it. They need it. The code says they have to have it. So whatever the reason is, I'm going to adjudicate that based on the testimony of the city's code compliance officer and the evidence presented depicting that the violation still exists. Proper notice has been given. I find in favor of the city, enter an adjudication and set a compliance date of May 18th, 2023. That's the abatement date. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated.
Number 49, as it relates to a storage that they have under the stairs that was built without permits. In essence, they need to either obtain permits or remove the storage. It's in really bad condition. Same conditions as the previous two cases. Spoke with the condo president, George, on the original July date, and they were granted an extension until September 2nd. As of that date, they did not comply with obtaining a permit or removing the makeshift storage. At this point in time, the violation still exists. The property was certified mail on March 7th and was also posted. We're requesting an adjudication as well as a monetary fine until they...
If I remember correctly, there was a lot of junk stored under a stairway, and it's exposed, right? If you show me the picture, it'll just refresh my recollection. But I remember seeing one with a lot of garbage stored underneath. Can you get that? Not that one.
Some more pictures on the bottom.
Keep going. Yeah, that one, I think that was what I saw. There you go. All right. All right, as to item 49, based on the unrebutted testimony of the city's code compliance officer, the photographs and the evidence presented depicting that the cited violation still exists, that proper notice has been given, I find in favor of the city, enter an adjudication and set an abatement date of May 18th, 2023. In the event of non-compliance, there shall be a daily fine of $500 until the violation is abated. Number 50.
Finally, number 50, this is as it relates to recreational vehicle violations. Basically, they've been storing trailers throughout the property. Same scenario, spoke with the condo president. They were given an extension until September 2nd, 2022. Compliance was not met. The property was posted. It was also sent via certified mail for the hearing on March 7th. And as of my final reinspection, trailers still remain at the property. There are several pictures of different trailers that are being stored throughout the property. In essence, the residents are using the property to store their trailers, not allowed. We're requesting an adjudication and a fine until they pretty much comply.
Okay, how many trailers are they storing there?
It's one trailer that they move around.
Okay. All right. Based on the unrebutted testimony of the city's code compliance officer, the photographs that I've reviewed, and the evidence presented depicting that the violation still exists and that proper notice has been given, I find in favor of the city, enter an adjudication and set an abatement date of May 18th, 2023. The event of non-compliance, there shall be a daily fine of $250 until the violation is abated.
Thank you.
Straight, that concludes all the items on today's agenda.
That's it.
Are we done?
Yes.
Thank you very much. Anything else?
I wanted to make a quick comment. I have a quick comment to make about number 51 on the agenda. I know that there was a back and forth. It's the dumpster case. There was a back and forth whether or not a permit was required for that. And in reading the language of the section, chapter 9, section 915, it looks like only a city-approved dumpster enclosure is required. There's no permit. I just wanted to bring it up because I know we've had cases like this in the past, and we never discussed having a permit. And that's not what the section says, unless I'm not reading an updated version of the code. But I just wanted to kind of make that comment quickly.
All right, and along the same lines, I read every section that is quoted by all of the officers, primarily because I'm curious. Here, it just says chapter 9, and it would be helpful if there was a specific subsection that governed the issue of the enclosed dumpster and whether or not there's a permit required for that. So, be specific when you cite a violation. Don't just say chapter 29 or chapter 19 or chapter 9. Just put in the specific section. Okay?
Thank you.
Okay.
Yeah, thank you.
Thank you, everybody. Enjoy the rest of the week.
You too. Have a good one.
Have a good one. Bye-bye.
Okay. Bye.
All right.
Recording stopped.